All right, I think we have everything set up. Good morning. Today is Flag Day. Let's all admire the flag. Apparently, it's the day of the year we honor the American flag. We should honor it every day, of course. We're proud citizens of the United States, but today's Flag Day. So happy day, flag. I don't know when the Georgia flag is honored, but today is the U.S. flag's special day. It is also a plea and arraignment calendar, which we will call in a minute. And then I think 10-ish, whenever we get through plea and arraignment, Mr. Reed is going to resolve a whole passel of cases. Is that still, fingers crossed, Ms. Charles? Okay, we'll see what happens. We'll need a defense attorney. And is Mr. Reed here? He's here. Thumbs up from Deputy Gordon. All right, plea and arraignment. Our first two positions are Mr. Conley. Is Mr. Conley here?
Good morning, Judge. I have not made contact with Mr. Conley, but I do want to let the court know there was a change of address entered in on May 24th. Notice went out June 2nd, and it looks like it went to the old address.
Okay. I'm noticing Mr. Conley has a case with Ms. Markowitz's name on it, who would become you or Ms. Feely, and he has a case with Mr. Webb's name on it. That would actually mean Mr. Cladis, who is starting a trial today, can't be with us. Is this one of these new scenarios where the conflict defender management says, well, you don't have a conflict now or on this case, or how do we have both of you in the mix?
Yes, Judge. So the case that has Ms. Markowitz attached to it, that's actually an older incident than the first case. The first case on the calendar actually has a true conflict involved. However, the second one, when I sent in the conflict paperwork, it was rejected.
It bounced back because at the time of the incident in the newer indictment, there was no conflict, or?
The rule, as I have been told, or as I understand it, is only true conflict. Like if there's no real conflict in the additional case, then it has to stay with us.
So just so I understand, like a true conflict would be in the 21 SC, Mr. Conley is a defendant and Mr. Jones is a defendant, and you all represent Mr. Jones. You cannot represent me. That's a true conflict?
According to what I've been told, Judge.
Okay, I'm just wondering what that term true, because that's a conflict, whether it's true or major or significant is a conflict. So no Mr. Conley in that scenario because you have Mr. Jones. But then I guess in this 22 SC case, maybe it's a standalone, it's only Mr. Conley, not the same incident, not the same alleged victim. Looks like the victim is a piece of property rather than a person. The conflict defender's perspective now, workload management, is, well, there's no conflict there. And so the guy's just going to have two lawyers.
Yes, Judge. So in the past, before this was relayed to me, we would be able to conflict off of the second case in the spirit of judicial economy. And when I got the email, it was, we are no longer conflicting off for judicial.
We're no longer being economical. And it's not just judicial economy. I mean, it's sort of economical advocacy as well. Although maybe two heads are better than one. So there is this new address of Oakley Road for Mr. Conley, but you're saying that the notice for today didn't go to that address. It may have gone to the old one.
Yes, Judge. The documents section of the case management on Odyssey shows that it went to a Fairburn Road address.
Okay. Well, that's too bad. Went to Mr. Franklin. It's already off to a great start. I assume if mail goes to Mr. Franklin, that gets routed, I guess, to you, Ms. Feely, as the inheritor. Not meaning this is your case, but is that what would happen if something goes to Devin Franklin at the public defender's office? Does it at least get open to see this is relating to a case he used to have, or does it automatically go to SCHR and then poor Devin Franklin's getting a big bag of mail every week?
I haven't actually gotten notices yet.
Okay. In his name or your name?
But my understanding is that would come to me, anything from, that would go to Ms. Patel or got sent to Ms.
Okay,
Patel.
because this was mailed to Devin Franklin, 100 Peachtree Street, et cetera. So I'm just curious where that goes.
We should probably check into that because
Please do. Just so, I mean, this particular one is a dumb example because I'm looking at the conflict defender case. So it also went to Mr. Webb, who functionally doesn't exist anymore. So that wasn't helpful. Went to someone named Natalie Fiacco, also your office. Look at 8 lawyers are getting noticed, but not Mr. Conley. Let's see, last one. Yeah, look at that, Fairburn Road, Fooey. Okay, reset for notice. Not sure what more we could do other than, I mean, it was Ms. Nelson who filed the change of address in plenty of time. All right, how about Sandra Lasalle?
Judge, this is my client. This was reset for us to try to track her down, and unfortunately her family has not been able to locate her.
Okay, so bench warrant, Ms. Charles. All right, we'll do that. If Ms. LaSalle resurfaces or surfaces, and there's a pretty clear reason why she wasn't able to make it to court, feel free to walk her in and work through Ms. Nelson, do what we need to do.
Thank you, Judge.
Sure. Keith Berry.
That is my case, Your Honor, and I don't see him. As soon as the call of the calendar's over, with the court's permission, I'll step out and call him, see if we can get an ETA.
Okay, you've had contact with Mr. Berry.
I have reached out to him, and I have not gotten responses so far.
Any reason to believe the phone number you called is his number?
There's not any identifying features on the voicemail.
It's the number in the file, but it's not, hey, this is Keith. If you're my lawyer, press 2.
Right.
No, okay. Ms. Charles, this ultimately will not be your case, but you're covering for today. Oh, we've got. Okay, well, we're going to see if the Ms. Feely can track Mr. Berry down. It's going to be a light lift for you. It's either an arraignment or a bench warrant. Okay, but this will be Mr. Thomas's case. All right. Darian Peters. He is in custody. So
he will be my client. If we could come back to this one, I have an offer I would like to convey to him.
Sure. Christopher Santos. He is on the call. Mr. Santos, you make yourself visible, please. There he is.
Judge, Mr. Santos is my client. If we could also come back to this one, I would like to step out and speak with him from my cell phone after the call.
Okay, Mr. Santos, were you able to hear that?
Yes, sir.
So Ms. Wood, your lawyer is going to give you a call, talk a little bit about your situation, and then let me know what the plan is for today. Maybe your case is working out. Maybe we're going to waive your arraignment, but get things moving along. Looking at the charges here, it may well be something that is workoutable today, but that's importantly a conversation for you and your lawyer to have privately. So she's going to call you. You may have to drop off this Zoom session to talk with her. That's fine, but you'll need to plug back in. I'll need to say you're all set and you can be done for the day. It's okay if you drop off to talk with Ms. Wood, but make sure you hop back on, okay?
Okay.
All right.
Would you like for me to call you now, Ms. Woods?
I'll call you after the call of the calendar, okay?
Okay.
All right. Jason Sherman. Hey, Mr. Sherman. We've got no lawyer listed.
Judge, I believe if he wants a public defender, he would need to qualify today.
Okay.
I don't believe he has spoken to anyone from our office.
Okay. Based on his numbers, is it you or Ms. Feely would talk to him, or I don't?
The lower number is you, but
One of us will talk to him, Judge.
Okay. The cases are only 2 numbers apart. We have 498, 499, and 500. I say the wheel's not working very well. So Mr. Sherman, you should sit tight, please. One of the public defenders will talk with you, and I'm gonna need to talk with you. So you should not leave until you and I have had a conversation, okay? Thank you. Michael Simon. So that's a direct indictment. Is there a grand jury warrant out for Mr. Simon? Maybe someone from Ms. Patel or Mr. Whitenauer's unit could. No warrant is the answer. Let me look at the case. So it's a direct indictment for an incident from 8 years ago. So I will not be issuing a bench warrant. This is an event that allegedly occurred in April of 2014. So wherever notice went, the fact that Mr. Simon didn't get it, I'd be in bench warrant status right now too, having moved in the last 8 years. So I guess you can let the team know that they're going to want to maybe get other information about him. What do we do about this? Judicial hold. All right. Moving right along. The last one on the calendar is Jarvis Hillman. Oh, yeah, this doesn't list charges. This was a FTA, just to see if, to use lots of acronyms, if PTI had been completed. Is Mr. Hillman here? He's here. So it was Ms. Patel's case. So I guess, Ms. Feely, you could talk with Mr. Hillman, and says Ms. Hall. I assume that means it's now your case as opposed to it's a some kind of CWAC thing. So why don't you guys talk about it, and then unless you already know what we're doing.
I've spoken with him. I visited him at the jail, and we have spoken. I believe Miss Patterson is going to go see him tomorrow or Thursday. So hopefully we can have, because this was a diversion type case. It's very low level kind of, and he's got another CP case that's similar, all stemming from the same issues. So we hope to return with something to get Mr. Hillman released with some stability.
Do we need to bring Mr. Hillman out today? Do you want to talk to him while he's here?
I'm happy to talk with him while he's here and just let him know to expect Miss Patterson, but we had a long conversation already.
So why don't you let the deputies know when you're done with Mr. Hillman? They'll get him where they want to get him. He doesn't need to come out. I don't want to lose track of his case. So what should we recalendar this for? I mean, 30 days out on inquiry, is that, I mean, inquiry is the next thing it would be on for. And I won't be lifting the warrant, obviously, until there's a plan. It doesn't need to be 30 days. It could be less.
Would prefer less. Maybe, does the court have anything in it? Well, I think we'll have a little bit more visibility once Ms. Patterson speaks with him, because we are going to be requesting records. But I think 2 weeks would be my preference if the court has anything. Okay.
I'll work with Ms. Nelson, and if we have capacity there to, does Mr. Hillman need to be in person? Can he be Zoom? I don't know. If you've got a preference, that'll just inform us where he should go. We have, for everyone's planning, I think I've already told you this, weekly, of course, we have inmates. Tuesdays, we get inmates every Tuesday. The Zoom has been less regular, but starting the week of 4th of July, we'll have a weekly Zoom day. So instead of it being like every 9th day, and it's not always a Tuesday, I don't remember what day of the week we are. Wednesday. So every Wednesday, unless we're in trial, we have the ability to have up to 15 Zoom people. Every Tuesday is inmate. So we're Tuesday, Wednesday. For your planning purposes, just going forward. So, hey, could we bump this out 2 weeks? Sure. Could it be Zoom? Yep. It's going to be a Wednesday. If it's going to be in person, it would be a Tuesday. But because we play well with others, always have the ability, if it's one person, we can bug another judge saying, are you using all? No, we got a couple extras, and bring so-and-so over on a particular day. This doesn't sound like it's that sensitive that it's got to be that Thursday or he can't get in the program. But in the future, if you need someone brought over, bringing someone over a one-off because it's a plea, like, what was the guy's name that you guys finally pled out? Mr. Armed Robberies. Trim. Right. If you said, look, we could do trim, but it has to be this Friday, we'll make it, we can bring someone over. The Zoom, we can't borrow other people's Zooms. That gets real complicated out at the jail. So Zoom will be Wednesdays after 4th of July, every Wednesday. Inmates still always Tuesdays, but if you've got something momentous that needs to be dealt with on a particular day, let Ms. Nelson know and we kind of beg and borrow and we share. We're not using all our inmates' days today, and so people can borrow some of ours. All right, so I don't need to talk with Mr. Hillman. We'll see if 2 weeks can happen. It won't be before then. It might be a little after that. We'll aim for that. So to recap, reset bench warrant. You're going to try to track down Mr. Berry. Mr. Peters is here, and you're going to talk with Mr. Peters, Ms. Wood?
Yes, Judge.
Okay. Mr. Santos, you're going to talk to, he's virtual. Mr. Sherman needs to sit tight. We'll figure out if you all can represent him, and that's it. Okay.
Judge, I have an off-calendar matter.
Yes, ma'am.
Ms. Charles, if you could please, Ms. McCauley, stand in. The gentleman that we handled from the Virgin Islands
Yes,
on Friday, I believe.
I remember him.
I just received an email from his attorney there. Apparently, they are not wanting to release Mr. Prentice without an official order from us. I had sent him the warrant cancellation notices, but he said he needs something more official.
Okay.
So I don't know, would it be?
If you can send to Ms. Nelson, the official warrant numbers, names, dates, whatever it is, I'll write up an order that says, I hereby cancel, lift, expunge, and terminate. And then we can just list the warrants. But I assume what they've got in their system is warrant 1, 2, 3, 4, 5. Just want to make sure I'm referencing those specific warrants.
Yes.
That won't have much effect here, but apparently will be magic down in St. Croix.
Thank you, Judge.
You're welcome.
Your Honor, this is ADA Hiles on the Zoom.
Oh, down at the beach. How are things?
They're great down here. I wish I could make this more permanent.
Yeah. You almost look like you're in the Virgin Islands. You could say hi to Mr. Prentice, but that would be a very long conversation.
I know. Was Mr. Tyrone Robinson brought over today? He was not calendared, but y'all did send a transport request last week.
Yes, and I got the thumbs up from Deputy Gordon. He is here, and that's what we'll do while the other lawyers are talking with clients or potential clients. We'll bring Mr. Robinson out to have. So that's why you're here. So I'll ask Mr. Robinson what his plan is, and then you can go back to Beachland.
Thank you very much.
You're welcome. All right, so Ms. Wood, I'll get that order out as soon as you get that info today, tomorrow. And why don't you all please talk amongst yourselves and your clients. And Deputy Gordon, I need to see you before you get Mr. Robinson out here, but we'll get him out here. Take care of that. We do it. Okay, just let me know when you have. Okay. I'm waiting for it. Let me see. Okay, see?
I'm gonna call Barry first, and then if I need to talk to him.
Hear that? Yeah,
Or I guess
that's
Josh.
interesting. Don't tell anyone. Oh, are we getting Mr. Robinson out? Oh, is he getting Mr. Robinson out now? I wasn't clear, I guess. I had to talk to him about what I needed to. And then if we can bring, is he in the middle of that? Oh, he's back. Can we bring Mr. Robinson out? Yeah. Thanks. Because we got our beachcomber who can go back to doing whatever he's doing. No? Okay. Wonder how it made its way on there. What, so you got like name, rank, serial number, and it says there's nothing there? Okay. Whoop. Did you break Ms. Rivers' equipment? Were you able to find anything in the system about position 7 or 8? You confirmed it with the other county? No, I'm asking. No, it's not there, or they're not gonna, it's not active. Okay. Hey, Mr. Robinson, if you just come to the podium, please. All right. How you doing today?
Good, and you?
Good. I'm doing all right. We are not talking about the substance of your case, anything like that. We're talking about representation. I don't know if Ms. Taylor told you she has withdrawn as your lawyer, but she submitted paperwork saying, I'm not Mr. Robinson's lawyer anymore, and I'm withdrawing, and the paperwork was sufficient that I signed it. So Ms. Taylor is no longer your attorney. Is that news to you, or you knew that?
I just knew.
You knew before, or am I the first person telling you, or you already knew that?
Nah, she told me she was gonna do that though.
Okay, so she told you. She's off. I need to know from you whether you or your family or folks close to you are planning on hiring someone else, or if you need me to appoint a lawyer to represent you.
I'm gonna hire another attorney.
Okay. What's the schedule for that? Is that something you're thinking you'll do in a couple? You're not making any money right now, so it would be family that's doing that. Are they able to do that this week, this month? You've been in for a long time. You are definitely due a trial. Ms. Taylor wasn't ready when I thought everyone was ready. So we need to get that new lawyer in place so he or she can get all that discovery, talk with you about it, talk with the prosecutor, et cetera. You have a time frame?
Possibly by next month.
Okay. Do you have a lawyer in mind, or is it your family doing this, or a girlfriend, or who's looking for you?
My best friend.
Okay. Male or female?
Yeah.
Okay. So a guy, he is looking for a lawyer. Has he given you some names? Hey, I think it's going to be so-and-so.
Yes,
Okay.
Sean.
And is there a particular person and you guys are negotiating, hey, what are you going to charge us to represent Mr. Robinson?
Nah, he haven't came up. He was trying to come up with the money first.
Okay. But he's been talking with a specific lawyer.
Yeah, he said he got one in mind.
Okay. All right. So we should talk again, I guess, in a few weeks, so I can get an update. I don't want to rush you, but I also don't want you sitting in jail any longer than is absolutely necessary before we can either get you a trial or your new lawyer says, hey, I've worked out a deal that Mr. Robinson's willing to take. One of those things needs to happen sooner rather than later. But nothing can happen till either you hire that lawyer or we appoint someone for you. So should we talk again in a couple weeks? Should we talk in a month? What's the right amount of time where you think you'll have an update? Because it doesn't make any sense to talk tomorrow. You're going to say, I don't know, man, my friend's talking to this lawyer.
By next month.
Okay. So it's June. If we bring you back here or get you on a Zoom screen in the middle of July sometime, you think you'll have more news?
Yes, Sean.
Okay. Well, we'll do that. We'll bump this out about a month. And if your answer is, I don't know if it's going to happen, then we should talk some more about getting a lawyer appointed to represent you, because we don't want this to take forever. Does that make sense?
Yes, Sean.
Okay. Any questions about any of the stuff we just talked about?
No, Your Honor.
Okay. Then we'll see you in about a month. Hopefully you'll have some good news for us that, yep, we got this guy and he's on board. Okay.
You have a nice day.
You have a nice day too.
Thank you, Your Honor. May I be excused, please?
Yeah. Yes, you may. Go back, enjoy whatever you're doing.
All right, bye.
Bye. How quickly could he get off? So the system shows 2 from Clayton with numbers, but I don't believe you. They're from 2021. They're not all that old.
So it's not that. And it's not a system.
Someone should call Clayton.
This is his job, that's you.
Zero, 5, 6, 0, 7, 6, 3, 4. It seems like they should deactivate it. on our side.
Right, so it doesn't flare up. It's just gonna make life complicated for him.
He has another case that's getting about,
It went to Ellerby.
warrants for, are those, well, take this little bit around the village.
Right, exactly. I'm amazed it's not already with us. Although, I guess it's a few more weeks, and then it's not Ms. Little.
And I like that.
Yeah,
Take your. It's just to get back to the criminal.
I think that's right. I think this may be what Ms. Charles got accused. So Mr. Reed has a new case and it went to Judge Ellerby with 20 counts. This is the beast that you put together. Okay, so it should come, I mean, everyone knew it was coming. He had to hit the wheel and it, part of what we would do today. Okay,
And he has another one that just been transferred to his 22. Yes.
Yeah, two of the
118, 16. That just came.
all right. Is that from Dunaway? That's who moves fastest, I think, is, what's her name? Tammy? No, they move pretty fast too.
I don't know. But she has a new case.
Just wait a month.
So they need to be arraigned with this case. If we did that, that'll be easier. If they don't resolve.
Yep. So Ms. Charles, you've spoken with Mr. Jerome and think there is a deal, or what's the status of? You don't need to give me the specifics. I'm just curious if he's here and you're here.
The issue in the middle is the DD case.
Uh,
I'm proposing for the burglaries.
Oh, the-
DD case is, Mr. Thomas, I don't think Mr. Thomas and Mr. Jerome have spoken.
okay.
I've communicated with Mr. Jerome, what Mr. Thomas told me what he's looking at.
And are you deputized to handle the 151 is the DV case?
The current posture, no, I'm hoping Mr. Thomas will come off the message.
Okay.
Another issue is the amount of restitution in the burglaries. Mr. Jerome is going to push back on that. And so there's one particular victim who was an enormous amount, hundreds of thousands of dollars worth of items, over $200,000.
Did he make an insurance claim? Okay.
And so I said, so my last thing.
That may be one where you say, hey, if he wants.
Let's put that aside, TBD, and another guy, another victim with a bunch of rifles, no one's evidence of that. So let's put those two aside, but we have, that's about $20,000 to the other side. So let's work on that, and let's close out all, the burglaries. He said, the last one he said to me, on Friday, yesterday as well, was they want to try the DV case. So we can close out those.
Go for it. We're ready. We got some trial calendars coming up and it's not yours. So it could be that week you're gone. Yeah.
Close out the smaller ones, as I said, the drug one, but 18.
Okay. Well, we'll find out in about 20 minutes.
So the radio that we have in the embassy right now, so we just stand there.
Oh, everything okay? In the building or somewhere else?
I think it's something technical.
A technical emergency?
It's not
Okay,
emergency, but when they do that, they told us to not.
leave them alone.
So,
Okay.
I was just gonna ask my question.
Sorry.
I just texted you.
I'm not on my phone.
It's totally fine.
That number is on the- I had it in my bag, so.
So Ms. Wood, you've got Mr. Sherman with you. Tell me what you've learned about your office's ability to represent him.
Judge, he makes a little bit too much money for our office.
Okay,
I informed him that I would ask for a reset for him so that he'll have time to actually link up with a private attorney. He does have a question for the court, though. He's got 2 ankle monitors on his, like, both feet.
And the reason I have to is when I was in the court last time, I told the judge I was paying on it, and I told her I couldn't pay on it, and I told him I would stop paying. She said, "Well, we'll get somebody to take it off and give you one because they're free." And then when I got out and I said, try to call the ankle monitors, 2 different ankle monitor people, they said, "We can't take it out. The judge got to tell you whoever put it on." I said, "Man."
so that's interesting.
2 ankle monitors.
You've got a couple things we need to work through. So 2 ankle monitors, you probably don't need both. You also have 2 warrants out of Clayton County that we're working through. And until we can work through those, you need to sit tight with us. If they are valid, active warrants, we have to take you into custody.
This ankle monitor is for Clayton County.
Well, that may be why they're not active warrants anymore. They're showing up in the system. And so we're reaching out to Clayton County to make sure that they should be deactivated because you've got the ankle monitor.
Had it for a year. I've been on this one for a year.
Okay. And that may be exactly the situation.
And I haven't-
But they pop up when,
I haven't heard from Clayton County in a year because I haven't been to a trial yet. I
okay.
paid to get
But
out.
that may also be why there's a warrant, because they may think they sent you notice and you didn't get it and they wanted you in court. So I don't know. We're going to work through that. But are both those ankle monitors from Clayton County?
No.
So then why did you say, hey, the Clayton County warrants are why I have these ankle monitors?
No, the warrants are why I paid $3,000 to get out of Clayton County a year ago. I stayed there 5 months. When I got out, the probation, the bond people said they're gonna bring you an ankle monitor and you're gonna be monitored, and it's did the address and it gave me the rules. And I've been on the ankle monitor for a year, and I only been to Clayton County once. I haven't even started my trial or nothing yet.
Okay, but are you on the ankle monitor because of one of these Fulton County cases? Because of a Clayton County case? Okay, I can't do anything with your Clayton ankle monitors then. That'll be Clayton that would.
That's why I'm talking about the Atlanta, but it's still from my same address. I had to be, you know what I'm saying?
Sure. Now you've got a complicated situation because you got business in Clayton and you've got business, 2 cases here in Fulton. But if the ankle monitors are courtesy of Clayton County, it's a judge down there who would need to say, hey, make this silly. He doesn't need 2. One does it. Maybe we'll give him 1 on each wrist too. And we know where every part of him is all the time. So it's a great question to be asking. Do you have a lawyer for your Clayton cases?
I haven't even been called to arraignment.
There's no case to have a lawyer for.
Yeah, I haven't been to arraignment yet.
Okay. Well, you do need a lawyer for these 2 cases. And I am going to reset this a bit for you to have a conversation with a lawyer or 2, see if you can retain someone, hire someone. But I need you to sit tight while we work through one last bit about these warrants, because I'm getting conflicting messages of they're inactive, not from you. Your message is very clear. I have the ankle monitors because the warrants were for that. But one system is saying there are these warrants that are active, and another system is saying, no, they're not active. We just need to get it right. So if you don't mind, she's sitting in the jury box. If you just sit in one of these comfy chairs here, we're not going to forget about you. And we'll get to the bottom of it. Okay. Mr. Sherman, while you are waiting, how much time do you want to try to line up a lawyer for your cases here? Because I don't want you to come back next week to say, I need another few weeks. You heard the conversation I had with that gentleman who's in custody. Now, his case is, that lawyer's gonna cost him a lot of money. I don't know how much yours is, but your charges are very different from what that young man's dealing with.
I can say for 1.5, maybe 2, but I'm going a lot, and got a lot of cases coming up.
When you say a lot of cases, what else is coming down the pipe?
Clay County has a gang.
Okay,
That was like a year and a half.
okay.
Now they're on probation.
So you say probation, are you on probation for some other case?
No, I just, I get this mixed up between probation. Like, I just had a case from DeKalb County from like 8 years ago. Then they just settled it and gave me the regular, call once a month.
Yeah,
And I do that.
Okay.
That's what I'm referring to.
okay.
I haven't, like, Clay County, we haven't paid up yet. That's why they gave me the extra money, so they keep watching.
Nope, not active.
No, I called Whitney County and said that he was in that, they put the hold on sheriff's March 2021, but he was in custody at least July 1st of 2020.
Okay, and that's exactly what he's saying. Okay, all right. You're good to go with the warrants. What we're gonna do is reset. I'll make sure we got a good address for you, so that you'll get notice and we don't, I mean, you showed up today. Did you get something in the mail to be here? All right, let's. So I've got a Star Mist Drive. That's your address. Okay. You'll get something in the mail. I'll reset it for kind of early August-ish. That's a little less than 2 months, but I don't want to put it out too far. This needs to move forward. And if you absolutely positively can't afford a lawyer, maybe you'll have to provide more financial information to the public defender's office. But right now you fall into that category of someone who needs to hire his own lawyer. And I want that to be something you focus on. It won't go well if you come back in August like, oh, you know what? I haven't really looked into that. Because we need to, these cases won't just stay on hold because you decide you're not going to hire a lawyer. Either I'll say, great, then you're going to represent yourself, or you can get a lawyer. And representing yourself is rarely a good idea. Any questions about any of that?
No, I just want to know, is there any, the people that gave me this monitor for Atlanta, I don't have a contact number for them. Because the judge told me to call them and they would take it off.
So you need to work through that judge who told you that. So that judge has a staff. You'll call that staff. Hey, this is Mr. Sherman. I was in court. They'll be able to look up your case. Oh, it's case 1, 2, 3, 4. Oh, ankle monitor is still on you. All right. Well, here's an order or something like that.
Yeah, I tried to call the Right Street chair, right? The court, that's how I want to court it. That's what she gave me this ankle monitor. I just don't have no way, or nobody want to help me. And but the judge just told me, okay, we never take it off. And then when I called him, like, the judge can't take it off.
So you're confusing me. I thought the ankle monitors are on you because of your Clayton case.
One is Clayton, this is Atlanta. But they're telling me it's my same address. You know, they understand it because she said, the judge said, well, if you get this ankle monitor, we'll take it off. Because I already got it, because the lady said we want to prescribe an ankle monitor. I said, Judge, I already got an ankle monitor. She said, well, we're going to take that. She said, we're just going to take it off. And I can't get in contact with nobody to take it off. So I just got to get in contact with the judge. But I don't know how to go about doing that. That's all.
Well,
Find your case.
there's not even a bond in, I don't understand your cases.
I know.
There's no, the dockets just says calendar notice and indictment. There's nothing Usually the bond carries over from the CP for either of them. May have been, I mean, these are old events. One is from August of 2 years ago. So I'm going to try one more time to understand your situation. You have one from Clayton County.
And I just got this one a couple of months ago, where she told me.
So just stop. One is from Clayton. Is that the one you're trying to get off?
No,
You're trying to get the one from Atlanta off.
she said,
Just tell me which one you're trying to get off, Atlanta or Clayton? Okay. And what's the one that you had to pay for, but you don't pay for anymore, Atlanta or Clayton? So shouldn't the Clayton one come off?
No, because I haven't been to see, I haven't been even to court or to arraignment for Clay County yet. I've been out a year with this on.
Okay. And you don't pay for the Clayton one?
I don't pay anymore, because I told them I couldn't pay it. Then when I called, the people in Clayton said, well, you don't have to pay if you can't pay.
Okay.
And when I was in Atlanta, they didn't know I had this one on when I was in court. And then she said that Judge, I moved on to get my ankle monitor. And I told her, I said, no, I already have ankle. She said, Judge, we already have an ankle monitor. And he said, well, it don't make sense when I had two. And then they put it on me anyway before I was released.
Okay. When were you in Rice Street?
Maybe about 2 or 3 months ago.
Okay. I can't, there's nothing in here about being in jail.
I know, I'm large and they got me large.
Do you have a alias? Do you have any cases that aren't Jason Sherman?
They put it on my ankle anyway. She said, well, he don't need to. So when I made bond and waited for the bond, then they came out, I was going to release me. They brought me to the room, they put it on my ankle anyway. I thought, when I called about it, nobody got it. Like I said, I'm not even in case any system did about 2 months ago. I'm pretty.
Let me try that. Do you remember the name of the judge who gave you the bond?
No, sir, that's my main thing was I said, well, there's something they say, well, you got to get in contact with the judge.
Is your middle name Bernard?
Yes, sir.
Yeah, you have to have an ankle monitor pursuant to your bond. I found your booking number. Here's the bond order. Boy, it's under a booking number 2202610. See, he was booked in as a misdemeanor. This probably came from state court. Yeah, so that's one reason why it's jacked up. So the bond is in something called IR paperwork. So this bond says you have to stay away from 2180 Star Mist Drive. Who's Carlos Sherman?
That's my older brother.
Okay, I don't want you to talk about your case. Just want to know who Carlos Sherman was. You don't have a lawyer here. So.
Right, so yeah.
We should be able to call the probation and take the bond.
Yeah, that's who the bond is through, but I don't want this ankle monitor coming off. It's related to our cases.
Right fucking there.
Cue iPhone. Yeah, Carlos Sherman is the alleged victim in both cases. He has a bond that says he has to stay away from the address he's living at. So you're gonna need to, this is not going well. Print. I thought I just sent it. I don't know. There's a CP number on the bond. I'm gonna look up the CP number.
It's in this one.
900. Yeah, that's one of the Carlos Sherman cases. And so the bond should have carried over. Hopefully either the clerk's office or the DA's office can clean that up. Whoops. So I've got the monitoring company, but I don't want that ankle monitor to come off. That's the ankle monitor associated with this case. It's a condition of your bond that you got on March 1st of last year, that you have no contact with Carlos Sherman, that you stay away from 2180 Star Mist Drive. But that seems to be where you're living right now.
I'm not gonna stay there. I'm no person stay there. It's my family house. So I'm not gonna stay
Okay, I'm just telling you what your bond says.
there. I don't, you know, I don't stay, I don't be there like with this. This is like really why I stay. I'm not gonna stay there. I stay with my girl because of that.
Okay,
But it's literally no one there.
where does Carlos live?
I looked at council of the growth and he's in the hospital. He got like 2 more months.
Oh, sorry. This just printed out 1 million pages. Well, all I can tell you is you're going to want to talk to Clayton County about getting that ankle monitor off. You will get notice for when you need to be back here, and you ought to have a pretty clear idea as to who your lawyer is going to be, how that's going to work out. Okay?
Thank you.
All right. All right, let's see what else we can do. Go back to the beginning of the calendar. Keith Berry, any luck finding Mr. Berry?
Unfortunately not, Your Honor.
All right, bench warrant,
Yes, Your Honor.
same as Ms. LaSalle. If Mr. Berry pops up, you can walk him in. How about Mr. Peters?
Just we're gonna waiver in this day or plead not guilty and ask Ms. Patterson to assist us with this one.
Okay, let's bring Mr. Peters out just so we can meet and he can hear that.
Yes.
Hey, Mr. Peters, how are you? We just had to come up to the podium for a sec. We'll have a quick conversation. I'm Judge McBurney, and your case has been assigned to me. Today is your first appearance now that it's been indicted and assigned to my division. And I was chatting with Ms. Wood, your lawyer. She's going to have some people from her team come talk to you out at Rice Street. Ms. Wood has said right now you're going to enter a plea of not guilty to the charges, which means then that we're going to start the process of having the prosecutor, that may be Ms. Charles or a colleague of hers, get all the state's evidence, give it to your lawyer so she can talk to you about that. And then you and your lawyer, Ms. Wood, will figure out, well, what are we going to do next? Are we going to file some motions? Are we going to try to find a program for you? Is it going to be a plea? Is it going to be a trial? I don't know the answers to those questions, but I'll get answers from you and Ms. Wood when we next talk, okay? Do you have any questions about anything?
Yes, am I able to talk one more time with my public defender?
Yeah, I think so. I couldn't quite hear you. Can you say that a little louder?
Am I able to talk one more time with my public defender?
Oh, sure. I mean, today?
Yes.
Sure. Ms. Wood can go back and talk with you, and she will come see you soon. Once she gets that evidence from the state, there'll be papers. She can give you copies of some of that. So she'll come see you. And as I mentioned, a colleague of hers, probably someone named Ms. Patterson, is going to talk to you as well about some ways that you might be interested in working this case out that maybe gets you plugged into some support, some programs, who knows what. But so it could be two people who come visit you. One for sure is Ms. Wood, all right? But I'll have Ms. Wood come talk to you in just a minute before they take you downstairs.
All right, thank you.
You're welcome.
Thank you, Judge.
What are we doing with Mr. Santos?
Judge, I do expect a plea on this one. I just need to call him one more time.
Okay,
Um,
you expect a plea today or a plea? Okay,
today.
great. Then that's it. So you could have gone inside. I wasn't sure what was left. So Santos will likely be a plea. Prentice, you'll get me something. We dealt with Tyrone Robinson. And so we're just waiting on Mr. Jerome. All right. I'm going to go back there. Ms. Nelson, let me know if Mr. Jerome gets here and folks need to talk or folks are ready to go. I'll come out for that. Otherwise, I'll come back out for Mr. Santos. Thanks. Thank you for the trial calendar. Get that going.
What's happening? Me. Again. What's happening?
All right, so I need to speak to my client for a second, and then I'm gonna get out and let you know, but more than likely we are gonna clear down today. What?
I'm gonna put stuff. I'll come to close it.
All right, that's fine.
I'll go. I'll just tell this. I'm just gonna get 2 hours. Because I wasn't sure.
Well, let me talk to him first,
Okay.
just to make sure, and then I'll come back and let you know. Thank you very much.
That's just the regular.
So he was gonna do the DV also, so are you gonna be doing that plea, or is that gonna have to be a plea today? So let me talk to him and I was gonna text him once I was finished.
Yeah.
Yeah, but but still on the restitution, he's still gonna want that. Huh? I know, but $20,000 is a lot of money. Come on. Well, he wasn't involved, but he wasn't, what I'm saying? That's the thing. And that's what he keeps, emphasizing, is that he wasn't.
Actually, it's being broadcast in the waiting area. It's the young. So there's a few.
I just have one set of flags.
But yeah.
Well, that's what he was saying. He was there. But you got for 9 cases.
When I was out there.
Well,
The other guys are the same, but he's last week. What the thing is that
and they had it in succession. One was in March, one was in November, one was in the same June. They had a bunch of one person, multiple names.
You didn't send me this,
I
did you?
did. I know, it's that's in the older, that's in the previous case.
Oh, that's the last one. This is the one that's already. been-
This is already indicted.
Yeah.
This is not the one that I just indicted.
Yeah, this was the one I was having.
This is-
But you guys kind of, you do all this stuff to me. But anyway, let me take it.
You want to take this step back with me?
Yeah. Is that all right?
Yeah, sure. I'll take it. You can have that.
Oh, you want your paperwork?
No, I'll take mine. I'll take it.
Oh, yeah.
I was in my paper. I think this is staple. It was just, this is staple. This is just for that. So have a look at that one.
Are you Jamaican? Where are you from?
I'm telling myself as a student,
Yeah.
taking this.
The marijuana case? Huh?
Yeah. It's okay. You should just go into the burglary. This one.
But you want him to plead to all the burglars. We talked about 9 burglars. Right?
Not, it's like 3 cases.
9. No. Is it 3 cases?
It's 3 cases. I consolidated them.
Oh, so let me ask you this. This is the other thing I was wondering.
Okay. So
Well,
one
first,
has
if
19
he
counts.
pleads to these 3 cases, how's first offender gonna work? He can only apply that to 1 case?
I think you apply them all of them. As long
Can
as
he?
it pleads at the same time, yeah.
If he
Yeah,
takes
I
all
think
the pleas at the
Because if
same
you takes
time?
them all at the same time, then it's gonna count as one commission.
Yeah, because, are you sure?
That is my understanding.
That, I mean,
And that's what I've
I need
done
to go
before, and I haven't heard anything come back yet, so.
yeah.
I don't think he
you
does
have
the trial. I
to-
think if I consider it for trial, then he can get 1.
Yeah,
If I don't consider it for trial, then he has to take 1.
Yeah,
yeah.
because I played 2 cases out before something at the same time before.
Yeah.
So essentially, if he does, and that's, I mean, because that's one of his other concerns is the felony status. You know what I'm saying? And so if he can plead them all off at the same time and get first offender on all of them, that would make a big difference.
Let's,
I don't know.
do we have probation on here? Madam Probation, are you there?
So, but I understand what you're saying, but you gotta understand what I'm saying. You
Did
got,
someone call probation?
Yes, ma'am, we have a question for you. Hopefully you know the answer to it.
Sure.
If a person pleads to multiple cases at the same time, can he do first offender on all cases?
Not to my knowledge, just gonna be one of those cases as first offender because it's 1 case.
yeah, so I mean, it's.
Okay.
So
All right, thank
anyway,
you.
I
Yeah,
just,
I'll follow up and ask someone, okay?
All right, thanks.
so in the end, it's gonna be what, 3 burglary cases?
So it's gonna be,
Because if he does take the first offender, it's gonna be for the violence.
so it's a 19, 21, 4, 19, 21, 22, and 222 is the 222s. And the 121 and 119.
That's gonna make them the ANC or citizens.
Oh, you're breaking my heart. I don't want to tell her. I don't know what to do in this space. So what do you want?
No, I understand, but you know, at the same time,
I mean, he did it over such a long period of time.
I understand, but at the same time, and it's not that I'm trying to make him get away with something that he did. That's not what I'm trying to do. You know what I'm
So
saying?
you're going to the DV, what I'm gonna keep working on this back everything.
Well, let me talk to him. Let me
Chipping away at it.
let me tell you
Because
something.
what I can do, I can go back and talk to my deputy and say, okay, here's what's here.
I know that you've been working very hard already. You know what I'm saying? All right, and so I'm gonna do my best because I don't want to be on this case anyways. And so I'm gonna do my best to get this whole thing closed out today. I just can't guarantee it because, like I said, he said that he wasn't involved in some of these.
So he's gonna go non-negotiated.
You said what?
Is he gonna go non-negotiated?
Well, he's not gonna go non-negotiated because he doesn't want to plead guilty to them at all.
At all?
That's that's what I'm saying, because on some of these cases, he wasn't there. That's what I'm trying to tell you. You know what I'm saying? Because he'll admit to the ones that he was there. He'll tell me, he's essentially given me 2 dates and said that he was there. But you know, there's one from 2019 and there's one from 2012.
Well, in that case, I've got to do some more investigation for this business. So I can't do that. Because I'm gonna have to see if I get some cameras, because on the narrative, it mentions there were some cameras available on these ones. See, I had to, these are all the warrants I had to go through, and I've been requesting a body cam and requesting video. I've gotten 1, which is a tick. These are all outstanding because all I have was the warrant. So it's gonna have to be some more digging.
Let me take this, what you gave
But
me.
take this for right now, but I'm gonna have to
talk
pick some more. If he's gonna say more than that.
I mean, that's what he's saying. And so, but let me talk to him. And like I said, we'll see. You know what I mean? No guarantees, but like I said, I'm on your side on this one. I would like to clear it all out, get it closed out. I can't force him to do what he doesn't want.
I get it. I mean, the judge has some more dates before the end of the month.
Yeah.
So if I can just have, if he says, all right, I'm just, he's not willing to do the 2, because the one that this one, I believe it's, I think it's this one right here. And then the misdemeanor on this one.
Yeah.
So I don't know.
All right, give me 1 second. Let me try this.
You want to step out, I believe.
How did she get that? But I'm just like, how did you get that? All the boosters, everything. I'm wondering. I'm saying you, I can't believe it. Just gotta do it. Oh, she goes to church. And that's how you says. My mom doesn't pick one. This test. Every night at 11 o'clock. So do you think I can sleep after that? No, she's good. She's good. So you would tell me that she's allergies. She's not retest her. That's not. Oh, that's the first thing she did. Everything, sure, but she got 99 tests to the house. And exactly. And I open my phone, there's this text with the result. I'm like, oh, I just someone has
Oh, okay. Oh, okay, I didn't know, yeah. Okay, so. Is that your bag or Lee's? That's Lee's. Okay, I don't know where she went, but she must still be here. And then are you gonna go watch the trial
After this,
Smart?
yeah, she was so good yesterday.
Really?
She, like, that witness, like, you know, you see hostile witnesses on TV and whatever, no, she was just, she wouldn't answer questions, the judge multiple times, like, you have to answer that. The best situation was, you know, was that pretty slow. He was like, no. Yes, it was. And she was like, okay. So then she asked her, and she was like, so then she was like, she spelled out the answer. She was like, was the answer? And she was like, yes. So then Suzanne was like, okay, so she goes, no. I was like, okay, so what, like, and she was like, and I swear to you, the entire courtroom was like, what? Are there people watching? I think it's a lot of people because it's just like we had 5 PD interns and then there's a bunch of undergrads interning with the DA's office. Cool. So there were like 12 of them. Okay. So there were a lot of people, but it was not really anyone like other than a bunch of interns. Both of them are families. So the client's family, a whole bunch of them. Yeah, and this little sister, and she was, and I was like, oh no, I cannot handle this. This is too
I need to
fast.
stop by there before I go to the office.
Yeah,
Did they get through all of her testimony yesterday?
yes.
Okay.
Although I bet she gets off.
Okay.
Because they kept the subpoena on her and Suzanne like pretty clearly wanted her back. So I know. I know. So I bet they get through the next person. I left at like 4. The next person they both was the lady. Suzanne has a trial. It's really interesting too. It's
on the 5th floor?
5B. Yeah, 5B,
Yeah.
because it's right across from the office.
Right, it's convenient.
Yeah, it is.
Yeah, I just let them try myself.
Yeah, I noticed that too. And he's just like saying stuff, but he's like driving. While you can see like the trees. Like that just seems really weird.
Oh my gosh.
I don't know.
Usually like the judges like say something about that, like.
Yeah, I mean, and like maybe he did at the beginning, I don't know. Maybe there's like a good reason for it, but I thought it was weird. The ceiling?
Oh, there we go.
Another person.
Oh, okay. Oh, yeah, you're right. Yeah, you're done.
That's a good idea. Yeah, that's a 5B if you want to go watch. I bet it's interesting.
Yeah.
Well, the first day was wild.
Well, and there was so much stuff because Suzanne brought up like some gang affiliation, obviously from the Instagram handle and some other stuff.
Mm-hmm.
And then the prosecutor got really mad and was like, well, this is, you know, I didn't know we were bringing up gang stuff. Like, I'm going to bring up gang stuff with your client. And then
The rules are a little different.
I know. There was just like, because I didn't, yeah, it was very confusing. So I'm going to go down there.
Yeah. Jenny, she just got excused from Bonneville. And her with her accent. I have no idea. Everything was completely confusing.
Yeah. Well, then there was an attorney. I don't know if you saw her. There was an attorney outside that the people weren't letting in. She kept saying she was an attorney. And they were like, you have to call the judge and ask.
Because she was trying to bring her phone in?
Yeah, I think so, yeah. So she was just like sitting on the bench next to the judge, and he's like on the phone
with someone, because the judge wasn't on the phone on the screen, so I don't know who it was she was on the phone with, but she was on the phone with somebody trying to get them to let her in. Well, that's, yeah.
I wonder if we're actually YouTubing that one.
I don't know. Good question. Oh, I bet. I know, I've noticed that.
Yeah, I bet you one of the news stations has it.
I was gonna say, at
Yeah,
least
'cause they were
that,
up
yeah, at least that. How was Cox on Monday or yesterday?
Oh, wait.
Yeah, he is, isn't he? He's real like cold, kind of. He doesn't want to talk to you at all.
It's very like, I wasn't expecting to like, there's a mood.
No, it's like 3 seconds. He calls something. If they're not there, he's like, cool. And then he moves on. That's it.
Like,
Did you actually do?
so you have one meter, but the operation just I did a probation, but yeah, he like asked, do you know this? Do you know that? And no, like, there's
No discussion of that.
to be like, just like.
Had something you would have been a perfect person.
Oh,
I was the duty attorney. And so I roll in the office and just sit there waiting for work to find me, and find me it did, because at 8:25, the jail called and I got pummeled by intake and did 12 interviews in a row.
Oh my God, that's the thing. Like,
that's crazy. Why so many? Because it's a Monday?
Monday,
Yeah.
there was probably, do you know who's on the calendar?
Yeah, I never ended up following up with him. I mean, I did sit there for another while until I went to jail.
But usually, yeah, Mondays are usually very heavy.
But it was like, but I don't know where they were, if they were lined up, but it was very quick. And so it was like, how old are you?
Yeah.
Married, single?
You're just
How
like
many
asking
kids?
me
Where
the
do
same
they live?
questions over and over.
Where do you work? And he had a tie to the community, and one guy was like, well, I played basketball with the American Legion, and I was like, ties to the community, I'll allow
I'll
it.
it down.
Because if they get off track together.
You gotta pull it back on. Yeah, especially if you're doing 12 in a row like that, yeah.
Exactly.
So I just asked their name and actually so between them and I would like peer and stuff. And I was just wanted to. And she was charged with murder.
Oh.
And I was like, okay. So warrant to can't sit at home tonight.
No, you're not going to.
If you live away, you can totally go down the trial instead of like watching.
Oh, no, I'll
this. Okay.
I'm interested in this one. So.
Yeah, no,
I'll
no,
be in the
you're
building
fine.
for another little while.
Okay, you're fine.
Also, Lee, if you want to get my number from her.
Oh, yeah.
Anything, or yeah. Something else if you.
Right, earphones and that.
Yeah. Yeah, that's. Oops, sorry. That's one Monday. I'll do this email. Yeah, so
Yeah, that's fine. So like, she just gave me permission.
You're like, what if you do it slightly wrong? Then?
Right.
Yeah. It is 5 days. It's also my dad's birthday. Yeah, I texted him this morning. He was like, thanks. And I was like, that's it. Okay, sounds good. Sounds good, Dad.
Where did it live?
They live in Phoenix,
Nice.
but right now they're in DC
Living or visiting?
visiting.
Oh, nice.
Yeah.
We're ready. He's on Zoom. My client is.
Okay, so you're ready now.
Yes, ma'am. He's on Zoom.
No, was there was a. I think we want to do the Zoom first. That's why I'm asking you.
We take a food form there. We take a food form there. He can listen.
That's our bad.
Yeah.
Okay,
Well.
because yeah, we already handled the revocation, so I can send that to pre-indictment. That's fine. Okay, just, I just wanted you to know that I did take care of it and he was accepted. So yes.
Okay, so he was accepted for this or for the
For
revocation?
both, so they, yes, so they're allowing the revocation and then the unindicted case goes in the diversion trap.
Okay, so did you go ahead?
So, Mrs. Trump is,
Okay.
so I think she.
Okay, that's right.
But I just wanted you to know that. I didn't
Yeah,
forget about
okay,
it.
no, I appreciate it. I just, it was something, and they do record.
Right.
I'm used to seeing. Yes, I appreciate it.
Okay.
You can't send it to me.
Perfect.
I just wanna know what I was looking at.
Yes, thank you.
Thank you.
You guys get out.
No, you know,
Hi.
Hello, Mr. Thomas.
Hey, good afternoon or good morning.
Morning. I hope we're done while it's still morning. We'll see what happens. We are taking a plea, as I understand it, in Mr. Santos's case. And then we're doing something with Mr. Reed's. Got a lot. I think we're now to 6 cases, one of which is yours. Are you, the Santos case, I don't think is yours.
No, Your Honor, but yeah, so the position 2 on the plea calendar is my case.
Yep.
I do anticipate that to be a plea today.
Fantastic.
Negotiated.
Okay. Is Mr. Jerome with his client right now?
Yes, Your Honor.
Any idea where Ms. Charles is?
Ms. Charles, she had to run back to her office, but she will be back here shortly.
Okay, so we can't do Santos.
I thought she was in the hallway.
That's all right.
Yeah, as I understand, we were supposed to let you know when we were ready, so.
When someone said we were ready, which is why I came out. So it's all right. We're all good.
Ms. Consuelo Mack. You might be talking for a second?
Judge, I'm working on the email for Virgin Islands right now, so.
All right.
Maybe.
I'm not, I'll do it when you send it, so I'm not.
Your Honor, are you a hockey fan?
So I grew up in the Bay Area, not a lot of hockey there, but I went to school in New England, lots of hockey there. So I'm somewhere in between. My view on it right now is I just don't want the Lightning to win again.
Well, it mean you are best friends because I'm an Avalanche fan. I grew up in Colorado, so.
So my brother lived in Detroit for a long time, thick and thin for the Red Wings. And that's really where I learned most about it because he was a sports radio guy. And so during a certain time of year, he talked a lot of hockey. But I follow it just enough to say it's boring when the same team keeps winning. So is it Rangers Lightning? Is that the?
No, so it's the Avalanche and Lightning. Avalanche.
Oh, it's Avalanche again? Okay, so the Rangers lost to the Lightning?
Yeah, the Rangers lost.
Okay.
So.
Because I know Rangers and Lightning, that must have been semifinals.
Yeah.
So, and the Rangers were ahead for a little while, but.
The Eastern Conference Finals.
Okay.
So the Avs are back in Stanley Cup for the first time since 2001, which is awesome.
And do they stand? I mean, it sounds like the Lightning must be good if they keep winning and winning and winning.
They do, but the Avs have the best record in the league.
Maybe this is their year again.
Yeah, and I think everything's just lining up this year. So, you know, if we can have this, I'll go for another 20 years.
That'll hold you.
Yeah, so exciting time for Colorado sports right now. So.
It's from my hometown.
So you should be an Avalanche fan too.
I
Not a hockey gal.
Broncos.
Broncos.
Oh, definitely Broncos, yeah. What was that?
Can you reach out to Ms. Charles? Text, email, see what the deal is? Thank you. About as to where she is? Oh, okay.
So your, I just talked to her, she said she needs about 10 more minutes.
What's happening?
So she's printing out a bunch of documents that she's going to need for the,
This all relates to Reed?
yes, sir.
Okay. Is Mr. Santos able to hang in there?
Oh, I think he fell off the Zoom. Let me just send him an email.
At 11:30, a whole bunch of junior deputy clerks were supposed to show up. If that's still happening, I'll see if it is. I suspect the Reed pleas are going to take a long time. So we'll see how that plays out.
When's your last day?
July 29th.
So there's the potential of jury selection on this case,
Mhm.
and then also on this date.
Okay.
So you have that potential to see some.
That would be good.
Let me see. So like this calendar. I will be highly, highly shocked if that case does not go while you're here.
Okay. We have two.
Yeah, so. Yes. This is the Julie Island calendar.
Yeah.
So let's see.
You have one.
Actually, I have two on here.
Mhm.
Somewhere in the middle.
We have three.
There's
There's your
another guy,
one.
and then some private attorneys. And then. We just got.
Oh, this is on the 28th.
This one was supposed to go. I think the witness was out of the country.
Oh. Maryland has 2.
And then with this one, it's a really, okay. So,
Oh, gosh.
yeah, so it's actually. That's what it is to come.
Mm.
And then
Yeah, there's yours.
I think those are mine in there.
Okay.
That one,
Okay. I was gonna say, I feel like I recognize those names.
so this is a much shorter document.
Yeah, but it'll probably get added to.
I might ready to tell you, we have like a 50-person trial calendar in spring, I think it was.
Oh my goodness.
I don't know if he hears me. But he had like given us like certain dates.
Mm.
So it was like spread out. So it was like a 50-person trial calendar, but it was spread out over like, I think it was like 6 jury selection days.
Okay.
So this is a different, like, that's why it's much smaller.
Mm-hmm.
We'll see. So like other circuits, like the circuit that I used to practice in, it would be a massive trial calendar, and then the judge would make a short list. So it would make like the top 10, and then it would just like fall like dominoes.
He's back on. I'm assuming.
Oh,
yeah.
Wait, where'd he go? Oh, okay.
I mean, he's not. Yeah. And she's here.
No problem. So are we going to do Mr. Santos first? I think that's quicker, but I don't see him unless he's iPhone.
I just told him to log back in, so I think that's him.
There he is. He's iPhone. Excellent. So let's get him on the spotlight there. Ms. Charles, I know you were maybe getting some paperwork together in the Reed matter. Are you able to pivot to Santos so we can take that?
Yes, I had everything printed up, Mrs. Santos. Okay. When you're ready, and I'm ready.
Okay. Ms. Rivers, are you ready? This is position 6 on our plea and arraignment calendar, 22 SC 182490, State versus Christopher Santos Jr. Mr. Santos, are you able to hear me?
Yes.
Great. Mr. Santos is appearing virtually. His lawyer, Ms. Wood, is here in court. Mr. Santos, are you able to see Ms. Wood on your screen?
Yes.
Adding her, so there are 2 young ladies on the screen that should be bigger now. The one with not black hair is your lawyer, okay? The one with no mask, that's Ms. Wood. Mr. Santos, before we get started with your plea, I want to make sure you're comfortable waiving 2 rights. One of those rights is your right to be here in court. You're appearing remotely. It looks like you're on a front porch or a back porch somewhere, which is fine, as long as you tell me, Judge, it's okay that I'm not in court today.
Okay.
Is that correct? Are you waiving your right to be in court?
Oh, yes. Yes, sir.
Okay. The other right, you've got a bunch of rights, but the other one that is affected by you appearing remotely is you have a right to have Ms. Wood sitting right next to you so that if you've got a question, you can sort of nudge her and say, hey, I don't understand what that person just said. Ms. Wood is here in court. She's not with you. She is available for you to consult with. We can certainly make that happen like you have already. She could step outside and give you a call and you can speak privately. Are you okay moving forward with your plea with Ms. Wood here and you on whatever back porch you're on?
Yes, sir.
Okay, great. Ms. Charles, the prosecutor, is going to put you under oath in just a moment. Once you're under oath, it's important that you answer all her questions truthfully and completely. And if you have any questions of your own, do something, wave your hands, let us know because you can't hear what was said or someone just said something that didn't make sense. Will you do that?
Yes, sir.
Great. Let's get started.
Thank you, Your Honor. Your Honor, before we get started, the state will be moving to adjust count 1 of the indictment from felony obstruction to disorderly conduct pursuant to OCGA 161139.
All right. So it's a misdemeanor plea now. Two
Yes, Your Honor.
misdemeanors?
Yes, Your Honor.
Okay.
Mr. Santos, can you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may lower your hand. Please state your true, correct, and legal name.
Christopher Cartel Santos Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
I'm 22. I did one semester of civil engineering.
And are you able to read, write, and understand the English language?
Yes, ma'am.
And do you understand that you're being charged with the following offenses in indictment 22 SC 182490, misdemeanor disorderly conduct, and misdemeanor simple battery?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Did you go over your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms. Woods, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment?
So waived for purposes of this hearing.
Thank you. Mr. Santos, were you arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Santos, or your attorney know of any outstanding warrants that are related to these charges?
We do not.
Mr. Santos, has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to today?
Yes, ma'am.
For each count in the indictment, the minimum would be 1 day, the maximum would be 12 months. Mr. Santos, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 24 months probation with a special condition that you complete an anger management program and you complete 80 hours of community service?
80?
80. However, the court does not have to accept this recommendation. Do you understand, Mr. Santos?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have had the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself? Is that a yes?
if you didn't understand what was said, one, Ms. Charles could repeat it, or two, one of us could explain it.
Actually, can I ask,
I think he's gonna have a phone call for me, Judge.
Okay, great. You want to step outside?
Yes.
Yeah, so Mr. Santos, Ms. Wood's gonna give you a call. Why don't you drop off this call and just dial right back, okay?
okay.
Is this paperwork supposed to be just for the DV case, but all for both? Okay.
Like, is it wrong?
Yeah, I was just gonna go ahead and add all of it to this. Good morning, Your Honor.
Hey, how are you doing?
I'm doing well, and yourself?
I'm doing well. Thanks for joining us.
Yes, I have the plea paperwork for Mr. Marquezio Reed.
Yeah,
He's gonna be pleading out to 4 different cases today.
you don't need to fill out 4 different forms.
Okay,
Just one, and you can write, do you prefer just, we do one with 1 indictment number on it, or one with the 4 indictment numbers? Pardon me? Put all the numbers on, yeah, so just fill out the form once, and then at the top where it says indictment, you can write all 4 indictment numbers.
yeah,
And then we'll get it into each of the places.
all right. And then will he need to sign a copy of the indictment?
I'll do that electronically, so the only thing he needs to put ink on is the plea form.
All right,
Okay,
thank you.
thank you. All right, Mr. Santos, we're just waiting for Ms. Wood to come back in, okay? Okay. Coming back in. And you somehow turned sideways. I don't know what happened, but you now are hanging on the side of the planet. There we go. So is it like 98 degrees out where you are?
I'm not sure how hot it is, but it's pretty hot.
Pretty hot. All right. Well, we'll keep pressing on. So let's get back on the record in Mr. Santos's case. Ms. Wood, was there something you wanted to add before I have Ms. Charles repeat that question?
Well, I did just want to let the judge know, Mr. Santos, wherever he is, there's a lot of background noise. So I just reminded him if he has any questions about anything, just to let us know and we can repeat that for him.
Sure.
I think we're ready to move forward. I think Ms. Charles might have something else to add.
Okay.
After talking to Ms. Wood, Your Honor, we'll be adjusting count 2 from simple battery as well to disorderly conduct.
So it's 2 counts of disorderly conduct.
As opposed to.
Got it. Okay.
Okay. Mr. Santos, I'll repeat the last question. Do you understand that if you had gone to trial, you would have had the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of 2 counts of disorderly conduct in indictment 22 SC 182490?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the facts and charges against you?
Yes.
Do you understand that you may only have a limited right to appeal this guilty plea conviction? You will only have 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
Is that a yes?
Yes, ma'am.
Thank you. Your Honor, the state is unaware of any criminal history for Mr. Santos. There's 1 cycle in his GCSE and no felony convictions. And had the case gone to trial, the state would have expected to show that on March 21st, 2021, officers were dispatched to a fight call in progress. On arrival at 89 Centennial Olympic Park Drive in Atlanta, Georgia, Fulton County, officers observed several individuals engaging in this dispute. Most of the individuals dispersed once officers showed up to the scene. Mr. Santos and 2 other females stayed on scene. It's unclear from the report whether Mr. Santos knew the ladies in question who had continued to engage in this verbal argument. However, Mr. Santos was sort of in between the 2 ladies as they continued to engage in this argument. Officers asked Mr. Santos to stand down. Mr. Santos would not. He kept refusing to cooperate with officers, sort of mouthing off at officers as officers tried to go hands-on to put Mr. Santos in handcuffs. Mr. Santos on the body cam is seen as jerking his shoulder away. Eventually, both officers were able to get Mr. Santos under control and place him in handcuffs and then put him in the back of the patrol car, at which time Mr. Santos proceeded to be belligerent with officers, yelling that he was going to beat them while he was in the back seat of the police car. Based on the review of the body cam, we thought that the felony obstruction was not availing. It was more, the evidence leaned more likely towards disorderly conduct, his belligerence and unwillingness to cooperate with officers. And so as we ask Your Honor that you sentence Mr. Santos to 24 months probation with the anger management component as a special condition and 80 hours of community service.
All right, thank you. Good morning, Ms. Tucson. How are you?
Good morning. I'm well. How is everyone?
We're enjoying Flag Day. I hope you're enjoying Flag Day as well.
Yes.
Do you have any adult criminal history for Mr. Santos?
No probation for Mr. Santos, no prior record found.
Okay. And Ms. Jackson, greetings to pretrial services. Same question for you.
Good morning, Your Honor. The defendant does not have any prior arrests on file.
Okay. When you say prior arrest, there's one cycle and that's this case, or this case doesn't even show up on the GCIC?
Only this case, Your Honor.
Got it. So a true first offender. All right, Ms. Wood.
Thank you, Judge. Mr. Santos is 22 years old. He is a high school graduate. He was in Atlanta at the time of this incident celebrating his birthday. So this all stemmed from after a night out. He most recently was employed with Walmart, and Mr. Santos has indicated to me that he was working towards getting into the military at the time of this. And so that's why he's eager to resolve this today. So we do appreciate Ms. Charles working with us to get this taken care of. And we just ask that you accept the state's recommendation. I believe Mr. Santos might want to address the court, Judge.
Sure. Mr. Santos, I'm going to ask you a few questions and then you're welcome to share whatever you want to share. What do you do at Walmart?
I'm an order filler.
If I order Walmart online, you make it happen so that when I show up, it's in the bags?
Somewhat. I mean, I make sure it gets to the store so it can go in the bags.
Oh, you're at a warehouse, not at a store.
Yes, sir.
Okay. What branch of the military are you hoping to get into?
The Navy.
Why Navy as opposed to Air Force or Army?
My dad was in the Navy.
Okay. And is there something?
My sister.
And your sister's in the Navy. You have a naval family. All right. Well, there you go. You mentioned that you took a semester or so of civil engineering. Where was that?
In Sand Hills.
At where?
Sand Hills Community College.
Okay.
Sand Hills.
This evening, March 21st, your birthday, did you know the two young ladies that you were trying to keep apart or whatever it was you were doing with them?
Yeah, actually, that was my sister.
The naval officer?
No, I have a lot.
Okay, different sister. But it sounded like there were two females. Your sister was having a dispute with another woman?
Yeah, with her friend.
With her friend. Okay. And you were trying to play peacekeeper or you were getting mixed up with them?
No, I was trying to keep it apart.
Okay. All right. Got it. What did you want to share with me, if anything? You don't have to say anything at all other than answer my questions, but now's your time.
If I can get my recruiter to talk to anyone in the court or something like that, could I go into the Navy?
So here's my thought about that. You're going to be on probation for a while, 24 months, but
yeah.
If you, I don't know if it's a chicken and egg situation. If you get paperwork to Ms. Wood, who can get it to me that says, I'm the Navy and we're ready for Mr. Santos, like an acceptance or an admission or whatever it is the Navy does to say, we're ready for you to report to Camp Lejeune. It's not Navy, but I don't know where you'd go if you sign up. If I see something like that, I'm happy to make it work so that either probation becomes non-reporting or we do something that allows you to enlist or enroll or whatever the term is.
Yeah.
So you should explore that, but this is the chicken and egg part. It may well be that the Navy says, we're not going to take you until you're done with probation. But if they put that in writing and you get that to Ms. Wood, that is a reason for me to think, once Mr. Santos takes care of an anger management class and takes care of that community service, maybe we should make his probation be non-reporting or we suspend it so that he can get into the Navy. Either one works for me. You get in, but you can't go because of probation. Excellent. You're in. We'll fix it. Or they tell you, we would accept you, but we can't because you're on probation. I can work with that as well. In the meantime, you ought to take care of that anger management class and that community service because that I'm not going to waive. You'll need to do that. If you've done that, Navy is ready for you. I'll bet you we could make it happen.
Okay.
Does that make sense?
Yes, sir.
Okay. Anything else?
Nah.
All right.
Have a good day.
Whoa, no, I'm not done. I just want to know if you had anything else, not me. I got something else. All right, Mr. Santos, I find there's a factual basis for your plea. The 2 counts have been reduced to disorderly conduct. It sounds like your sister and her friend could have been charged with disorderly conduct too. It was late night. Folks were mouthing off, maybe not doing what they ought to have been doing. So I'm going to accept your plea. I also find that your plea is knowing and voluntary. Knowing means that you've understood all the things we've been talking about. And if you didn't, you had a conference with your lawyer, which you did at least once. Do you have any questions about anything anyone has said?
Nah.
Okay.
No, sir.
It is a knowing plea, and voluntary means no one's forcing you to enter the plea. You've decided that this is the right way to move forward in your case. Is that correct?
Yes, sir.
All right, then I'm accepting your plea. I will follow the negotiated recommendation. 12 months probation, count 1, reduced to disorderly conduct. 12 months probation, count 2, modified to disorderly conduct. Those will run consecutively to each other, one after the other, for 24 months. Special condition of probation number 1, complete an anger management course. You can find one, or probation can give you a list. Here are 5 different courses you could go to, but you'll need to complete one. And special condition number 2, complete 80 hours of community service. I am happy to revisit whether we end your probation early or we modify it in some way. If you've completed those 2 conditions and the Navy says they're ready to bring you on board, okay?
Okay.
Last thing I've got, your indictment is right now electronic. It's sitting here on my screen. Do you authorize me to sign your indictment indicating your guilty plea to the 2 disorderly conduct counts, Mr. Santos?
Yes, sir.
Ms. Wood?
Yes, Judge.
And Ms. Charles?
Yes, Your Honor.
Done. Last thing. How is he going to report to misdemeanor probation? You'll get that information to him? You'll get it from Ms. Nelson, Ms. Wood, and then you'll get it to Mr. Santos?
Yes, Judge. I usually can just fill out the little spreadsheet and send it between the parties.
Great. So, Mr. Santos, you're going to get some information from Ms. Wood or someone about where probation is and when you need to show up. Don't miss that first meeting, because otherwise they're going to reach out to me saying this guy's flaky and he's not participating. That will interfere with your naval ambitions. Okay? It's a tough time to have frozen up. You just had to answer one more question.
I'm gonna ask for you, so it'll be 2 years, July.
Oh, no.
Probably 90 days as of today. So
Mr. Santos, you there?
Yeah, so he's done 20 months, so he'd still have 4 months.
Is there a way you can text him?
Yes, Judge.
See if he says yes. That's all he needs to say. Oh, he just dropped off. I bet he's going to try getting back on.
Oh, I've never heard of that. Whether it's in the jail,
You said what?
so I understand, like, just in jail, so I'm not sure.
Let me just check on.
There he is.
All right, he's back. Hey, Mr. Santos, can you hear me?
Yeah, my phone overheated.
That's all right. We lost everything here as well. You probably can't see me anymore, but I can see you and hear you. You understand you need to show up at probation.
Yes, sir.
Great. All right, you'll get that info. You'll be good to go. Any questions? Or are you ready?
No, sir.
All right. Ms. Wood, anything else?
Mr. Santos, I will send you an email this afternoon after I fill out all the probation information, okay?
Okay.
Okay. Thank you.
Great.
Thank you.
You're welcome. Take care. Good luck with the Navy.
All right, man. Be safe.
All right. Are we ready for Mr. Reed?
So you're on thing? I think you answered the wrong, they went back and talked to me.
Okay.
Judge, may I be excused?
I guess you're done. Yes, ma'am.
Have a good one.
You too. There's Mr. Jerome. We are done with our other plea. Are we ready for Mr. Reed? You need to talk to him a little more.
Yes, Your Honor. I just wanted to make sure, we're just trying to figure out some things about his sentencing and the time that he's going to need to serve. So give me one moment, but we're ready. We've already signed up.
Great.
If you need the plea paperwork.
Great. So why don't you go back and chat with him, and then both of you can come out once you've had the conversation you need to have. All right, what other cameras do we need on? We've got podium defense. We'll get the prosecutor.
Prosecutor.
He did the gallery. I don't think we need to do witness just because no one's going to be testifying.
Not gonna take her after.
I can take anyone off. Who needs to go away? TAYON.
Can't leave the camera.
Yeah.
She could stay on, but not the camera.
Oh, too late. She's gone. She had nothing on? Wondering why you were Bobby.
Hello.
Yes.
Somebody erased my daughter, Tayon, Tayon. That's my Gracie Reed's sister. So can I have her sign back in, please? I'm his mom.
Not till she puts articles on.
I'm sorry, repeat that.
She needs clothing on and she's gonna have that camera on, otherwise she can join without the camera.
Okay, let me tell her.
Yeah. Yeah, I'm gonna make y'all wait till the close.
Could you give Ms. Nelson? Ms. Nelson? Yeah.
Somebody pleading the 4 cases.
4 cases, that's correct. Right?
That's the case that's on the calendar, right?
1, 2.
I'm not sure
yeah.
which cases we have on the calendar.
Yeah, they should be the ones. There's one that I gave Ms. Nelson a new number. There's gonna be, so there's, this one, hold on, let me go back. No pros. That's Travis's. That one. No pros because it's a duplicate of the bigger case I just indicted. The same victims are in that case. So I'm a no pros this one. And then the 2 that I indicted, the 222, so that's 4.
Let me see real quick.
Okay. So
I think I might have put, I
Okay.
put this.
So this
the
21, this 21 is the same victims in the 22. They were duplicates in one of the CP cases.
All
So
right.
I'm not gonna do it twice. So we're gonna cross that out.
That's all right.
So the 222 cases, you
Yeah.
got both 22s?
Yeah, 22, I see.
And then the 19, the ones you're missing is a 19. This one, 19 SC 17378.
All right.
19 SC. The DV case, and the 2 cases I just indicted.
And so this.
So we put you.
Have you- All right.
Okay, and then the DV.
Have you already filed a dismiss, or are you gonna be filing a dismiss on the 18th?
No, we
today?
do it when we do here.
Right now?
She will not pass indictment.
Okay. There's nothing that needs to be filed on that? All right.
Ms. Nelson will get that done.
Thank you.
I got you. We're gonna be very circumspect with this.
She
one.
wants to get this over with so fast.
No, we're gonna be very circumspect with it.
1 second.
Yeah, so, I'm really need a
If you have any questions, you ask me.
When necessary.
We'll try to streamline it for you guys.
All right, let's get on the record, please, in Mr. Reed's cases. It is June 14th, and I've got 4 cases on the calendar and learned of 2 others. We'll talk in a minute about whether we're resolving all 6 or 4 or what. But Mr. Reed, before we get any further, I need to repeat a little bit of an exchange we had last time, because we're meeting again. You heard me and Ms. Charles more so than I talk to you about a potential conflict that your lawyer, Mr. Jerome, has. Remember that conversation we had? And you told me you're fine with Mr. Jerome serving as your attorney because you felt, these are now my words, but I'm summarizing what you said. Mr. Jerome may have his business, but he's focused on your business in this case. And you didn't have a concern that Mr. Jerome's possible other business would be an issue for you. Is that still the case? You are comfortable having Mr. Jerome represent you? Great. Then we're going to proceed with Mr. Jerome as your attorney of record. Mr. Jerome, good morning.
Good morning, Your Honor.
I've got, as I said, 4 cases on the calendar. 2 are burglary, 1 is drugs, and 1 is the case Mr. Thomas is handling, the domestic violence case. I think the drug case is being dismissed, but I'll let Ms. Charles say that. Then there are 2 real new indictments, 22 SC, 182, et cetera. 1 has already been transferred to me from Judge Adams, and the other is so new, it's still with Judge Ellerby, right next door, 2 doors down, but we can handle today. She is fine if I take the plea on that. We don't need to, but I just wasn't sure if the goal was to resolve all of Mr. Reed's cases today. Those 2 new indictments, ones that went to Judge Adams and Judge Ellerby, they may even be accusations, but they're charging documents that Ms. Charles put together, I think in connection with negotiations you were having with her, Mr. Jerome, on behalf of Mr. Reed. So I'm fine taking pleas in those cases as well. But before we get into the plea colloquy and Mr. Reed's rights and everything, I needed you to define for me what you thought we were covering today. Which of the 6 cases?
So we're gonna be pleading to 21 SC 17815, 22 SC 182707, 22 SC 18262, and 19 SC 177786. 3 of those are burglary cases, and one of them, the 21 SC case, is a domestic violence
Okay.
case.
So let me ask Ms. Charles a question then. Ms. Charles, we've got 18 SC 158126, the drug case. What's happening with that?
This is, we'll be moving to null process case. We're no longer moving forward with that case.
All right, so 18 SC 158126, null pros dismissed. It's fancy for dismissed. That case is gone. And 21 SC 180131.
We're also null processing that case because the victims in that indictment were also reflected in one of the CP cases and is in the 22 SC accusation. Those
Got it.
victims.
So it's been subsumed in one of the 22 SC cases.
Yes, 2707.
Got it. So Mr. Jerome was spot on. There's a plea to a 19 SC, a 21 SC, and 2 22 SCs.
Correct.
Total of 4 cases. It looks like 3 of them involve these second-degree burglaries, breaking into storage units, and 1 very different ball of wax, Mr. Thomas's case. And how are we proceeding? Are you the primary narrator for the state, Mr. Thomas, other than the factual basis for the property crimes, or the other way around?
So I will be the narrator, I'll be reading the litany. There will be parts where we break off and I'll mention what's going on with the 21 case, position 2. And then attorney Charles will mention what's going on with her cases, just so we get everything on the record.
Fantastic. And everyone will be near microphones. So Mr. Reed, we're going to get started in just a moment. Mr. Thomas is going to ask you to raise your right hand so that you are under oath once you begin answering questions. Most of the questions will come from Mr. Thomas. Ms. Charles may have a few. I'll have some questions as well. Your answers to any question and every question need to be truthful and complete. Understand? And you got to make sure you speak up. And if you don't mind raising that microphone up, not that way, bend it up. Just point it as high as possible, and yet let Mr. Reed slide over a little bit. You'll want to belt out your lines. Mr. Reed, is real important that if you have any questions, if you're confused by anything anyone says, you let Mr. Jerome know, or you let me know, so that we can explain to you whatever's going on. I have to conclude at the end that you understood everything. So if there's something you don't understand, raise your hand or nudge your lawyer and we'll work through that. Will you do that?
Yes, sir.
Great. All right. And make sure you speak up. Mr. Thomas.
And Your Honor, just a little housekeeping on my position, 21 SC 178151. The indictment has 8 counts. The state is null process counts 3, 4, 5, and 7, which is 2 of the aggravated assault, family violences, and 2 of the cruelty to children in the second degree. We are moving forward on 1, 2, and 8.
Okay. Thank you.
All right. So, Mr. Reed, please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may lower your right hand. And please state the truth, correct, and legal name.
Quincy Reed.
Okay, you gotta speak a little bit louder for me.
Mike Quincy Reed.
All right.
That was great.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you're not being given today?
No.
How old are you and how far have you gone to school?
I'm 34. And what's the next question?
How far have you gone in school?
My diploma or GED.
Okay. Are you able to read, write, and understand the English language?
Yes.
You understand, are you being charged with the following offenses? So in 21 SC 178151, you are being charged with aggravated assault 2 counts of aggravated assault, family violence, 1 count of cruelty to children in the 2nd degree, and 1 count of a possession of a firearm during the commission of a felony.
Yes.
And ADA Charles will explain to you the other counts we're facing today.
In 19 SC 173786, do you understand that you're being charged with 4 counts of burglary in the 2nd degree?
Yes.
In indictment 22 SC 182684, do you understand that you're being charged with 1 count of burglary in the 2nd degree, 1 count of theft by taking misdemeanor, and 1 count of criminal trespass misdemeanor?
Yes.
In indictment 22 SC 182707, do you understand that you're being charged with 6 counts of burglary in the 2nd degree,
Yes.
6 counts of theft by taking,
Yes.
6 counts of criminal trespass, and 1 count of criminal damage in the 2nd degree?
Yes.
And Mr. Reed, do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Mr. Jerome, about all the facts and circumstances regarding the charges in these indictments, including any potential defenses?
Yes.
And do you need more time to discuss this case with your attorney?
No.
And are you satisfied with his services?
Yes.
Mr. Jerome, do you waive formal reading of these indictments?
Yes.
And do you waive any and all defects in these indictments?
Yes.
Mr. Reed, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know if there are any outstanding warrants related to these charges?
No.
Has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to today?
Yes.
In 21 SC 178151, for each count of aggravated assault, the minimum is 3 years and the maximum is 20 years. For your 1 count of cruelty to children in the 2nd degree, the minimum is 1 year and the maximum is 10 years. And for possession of a firearm during commission of a felony, the maximum is 5 years that can run concurrent or at the same time as your other offenses.
In 19 SC 173786, each count of burglary in the 2nd degree carries a minimum of 1 year, maximum of 5 years. In accusation 22 SC 182684, count 1, burglary in the 2nd degree carries a minimum of 1, maximum of 5 years.
I'm going to stop you 1 second. Is it 684 or 624?
624, I beg your pardon,
Okay,
Your Honor.
thank
You're
you.
right. It's 624. Count 1 to 5 years. Count 2 and 3, both misdemeanors, a maximum of 12 months. In accusation 22 SC 182707, each count of burglary in the 2nd degree carries 1 to 5 years. Each count of theft by taking felony carries a maximum of 1 to 5 years. Each count of criminal trespass misdemeanor carries a maximum of 12 months. Count 14 in the indictment, the amount of loss alleged is over $25,000. Therefore, that is 2 to 20 years. And criminal damage to property in the 2nd degree, count 19, misdemeanor, maximum of 12 months.
So, Mr. Reed, do you understand those ranges?
Yes.
You understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of, for 21 SC 178151, for count 1, 10 years to serve 2 years bounds probated. And as a condition, we are asking no violent contact with the victim in this case, Ms. Consuela Mack, and also no weapons and you must leave the Family Violence Intervention Program if you haven't already done so. For count 2, 10 years to serve 2 years, balance probated, and that will run concurrent with count 1. For count 6, 10 years to serve 2 years, balance probated, to run concurrent with count 1. And by concurrent, I mean running all at the same time. And for count 8, 5 years to serve 2 years, to run concurrent with count 1. You understand that?
Yes.
In indictment 19 SC 173786, for each count 1, 5 years of probation plus restitution to the victim. That will run concurrent with counts 2, 3, and 4. So a total of 5 years probation plus restitution. In accusation 22 SC 182684, 5 years.
It's 624.
I keep saying 84. I'm not sure why I seen 8. 624, 5 years probation plus restitution to the victims. And in accusation 22 SC 182707, the recommendation is 25 years, serve 5 years, commuted to time served, balance probated, with a special condition of restitution. The global restitution amount at this time would be $20,000, setting aside the restitution for victim in count 14, which counsel for the defense has requested a restitution hearing in that case. Stay away from all co-defendants and stay away from all locations in the indictments, along with a Fourth Amendment waiver.
Let me clear up one thing and ask a question. Criminal damage to property in the second degree is actually a felony. It's 1 to 5 years. Doesn't change anything for you, but someone mentioned it was a misdemeanor. Your sentence isn't going to change. Question, Mr. Thomas, your negotiated resolution to I'm going to refer to cases by their last 3 digits. 151 is your case. Was 10 to serve 2, balance probated. 10 to serve 2, credit for time served, reduced to time served, no credit for time served. What? Credit for time served. Okay. But not reduced to time served. Whereas Ms. Charles in 707, the big 25 to serve 5, those 5 are reduced to time served.
Yes, Your Honor.
Okay. I'm following it all. And the $20,000 global restitution is for 707, or it's across all 3 of the cases you're handling?
All 3 of the cases that we're handling.
Okay. Back to you, Mr. Thomas.
All right, thank you, Your Honor. So, Mr. Reed, do you understand what the state is recommending?
Yes.
However, the court does not have to accept the recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other. Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of a guilty plea conviction, just as there would be from a conviction following a trial? For example, the guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or your ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which will carry a sentence of 1 to 15 years in prison.
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes. Yes.
Have you ever pled guilty or no contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No.
Has your lawyer explained to you the First Offender Act?
Yes.
You understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced for up to a maximum sentence for each charge in the indictment.
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea.
Yes.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or by court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Actually, we're entering an offered plea on these burglary charges. So I don't know how that, I just want to just clarify that.
Okay, so which indictment is that?
Well, so step back. That's several indictments. As to Mr. Thomas's case, the one ending in 151, that is not an offered plea.
No.
Okay. But as to Ms. Charles's 3 cases, each of which involves some burglary allegation, second degree, those are all offered pleas?
Yes, Your Honor.
Okay. Is that news to you, and does that affect anything you're doing, Ms. Charles?
It doesn't affect anything that we're doing, Your Honor. It is news, but we can proceed as.
Okay. All right. We'll discuss that when it's my turn.
Okay. Are you pleading guilty because you have decided that it is your best interest to do so?
So I'm sorry, could you repeat the question? I was speaking to him.
All right, no problem. Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes.
Speak up, sir.
Yes.
Okay, so, and we're just gonna go indictment by indictment number. How do you plead in indictment number 21 SC 178151?
You'll need to let them know which one that is. I understand the number, but
And this is the BP case.
Guilty.
And how do you plead in indictment 19 SC 173786 is the burglary count?
Guilty.
How do you plead in accusation 22 SC 182707?
Guilty.
And how do you plead in accusation 22 SC 182624?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Mr. Reed. So Your Honor, I'll go through the facts of my case first.
okay.
And then I will hand it off to Ms. Charles. So in indictment number 21 SC 178151, if this case would have went to trial, the state would have proven beyond a reasonable doubt that on October 31st, 2021, Officers were dispatched to 3040 Middleton Road Northwest, and that is here in Atlanta, Georgia, here in Fulton County, to a shots fired call. When officers showed up, they made contact with a Miss Consuela Mack, spelled Consuella, Mack spelled Mack, and her 3 children. Miss Mack advised to the officer that there was a verbal altercation between herself and the defendant, Mr. Reed. The argument escalated, and as she was putting her kids in the car to leave, one of the kids alerted Miss Mack that the defendant had a gun pointed at their direction. Let's see, she described the gun as a black and pink handgun. And then she advised that the defendant did fire multiple times at the vehicle with her children inside. Officers did make contact with Mr. Reed, and he was detained for questioning and was arrested. During the search incident to arrest, a handgun was retrieved from his possession, which was a black and pink in color handgun. So, Your Honor, we do believe that if we went to trial, we would have been able to prove the charge we're moving forward with. We did dismiss a few of the charges because we thought that basically we thought it'd be better to not try to pursue those charges. So,
But just so I'm understanding, if your theory of the case is that Mr. Reed fired at a car that had Ms. Mack and her kids or their kids, but full of kids, the counts that you're not going forward on are other youngsters who were in the same car?
yes, Your Honor. So,
And it's fine if it's just, look, this is the product of negotiation. I'm just curious if it's that, or if it turns out they weren't in the car, or they were in the bulletproof section of the car, or.
No, so there is some question as to the direction of fire. And the two I am actually proceeding on, those are people who actually saw the gun.
Okay,
So that is what I'm proceeding on. I don't have the information that the other 2 kids saw the gun, knew what was going on.
understood.
So that is what I'm proceeding on today, Your Honor.
Did the car have any defects in it? So the car was not struck by the gunfire? And when you say a gun was recovered from Mr. Reed, not that his house was searched, but the police show up and on Mr. Reed is this gun?
And so and Ms. Mack is actually here in court today, and I'll talk with her about the recommendation. She is on board with it. She does not wish to address the court though. So I would ask that you do accept this 10 years served 2, balance probated, and then he has served 191 days in jail as of this. 591 days in jail as of this morning.
He's made some progress.
Yes, Your Honor. So we ask that he get credit for that.
Okay,
And then just make sure there's no violent contact in the victim's file. There's no violent contact.
and Ms. Mack's connection to Mr. Reed is that they have children
So
together?
the children are shared between both of them.
Okay, they're not married, but they have kids together.
I don't think.
Well, he can answer that, but you know for sure a connection is they have kids together. Okay. All right.
That's all from the state on that and on.
All right. Good luck walking us through what comes next, Ms. Charles.
Should do my best, Your Honor. Okay, Your Honor, in 19 SC 173786, had this case gone to trial, the state would have expected to show that on or around October 16th, 2019, Atlanta officers were dispatched to a space shop storage located at 2531 Lenox Road in Fulton County, Georgia. 2531 Lenox Road, Fulton County. Officers who responded met with the store manager, Nick Allen, who stated that he had noticed multiple units had been broken into. The locks had been cut off and the units were entered. There was a video surveillance at the location which captured 2 black males enter the location with a U-Haul truck. The passenger of the truck got out, entered a 4-digit code, which is a keypad to gain entrance. The driver stays in the truck and then the U-Haul pulls in. At this time, both males enter into the storage location and proceed to enter multiple units. Based on the code that was entered, the manager was able to identify the co-defendant of Mr. Reed, in that case, Mr. Khalil Chavez, who had rented the unit prior to that day using his ID, receiving that external PIN code and later coming back with his co-defendants to proceed to go into the neighboring units. On that same day, officers also dispatched to 1244 Collier Road in Fulton County, which is a USA storage facility, where officers made contact with one of the victims in this case, who stated that his unit had been burglarized and multiple firearms had been taken. Similarly, in the same fashion, 2 males were seen coming to a location, entering the code that goes to the external gate. Mr. Reed's co-defendant in that case is Mr. Garrett Anderson. The males then back up the U-Haul into the area, proceed to go into multiple units and remove items from that, the units. There was also video surveillance in that case, and one of the videos shows very clear shots of each of the assailants, which officers took a photo of. During the course of investigation, Detective Barry actually became aware of a similar string of robberies occurring in Smyrna. By Smyrna, police department had been dispatched to a scene at 2791 Cumberland Boulevard. Once Smyrna police appeared on scene, they were actually able to detain 3 suspects, Moncaso Reed, Montague Spruill, and Garrett Anderson. In looking through links, which is sort of a system that the officers talk to each other, Detective Barry was able to match the photo of Moncaso Reed to one of the suspects who had been detained in the Smyrna incident, tying him to the other co-defendants in the Atlanta cases. And that is how he was identified in the 19 SC case.
So before you move to the next one, since these facts are fresher, how is the 19 SC case an Alford plea? But what's the basis for me accepting it as an Alford plea, Mr. Jerome?
Yes, so Mr. Reed was, he was on the scene of 2 of these incidences, but on the rest of these incidences that the state has charged him with, he was not on the scene. Now, he was connected to this in the sense that he was the owner of the unit that the code that was used to access the building that was used. So he actually rented some of those units that received those codes that, the co-defendants used to enter the building. And
does what you're saying apply to these newer cases, the 22 SCs? Because this 19 SC I just heard about, it was a Khalil Chavez who used his PIN code and his rental of a unit, which got him a PIN code, got your client and someone into the Lenox Road, then the Collier Road. We're still in Fulton County.
Yes.
It's Garrett Anderson and your client caught on video. That video footage matches the person who then is arrested in Smyrna, your client, along with Garrett Anderson. So my question as to the 19 SC is, why should I accept that as an Alford plea? That sounds like it's a different set of facts than maybe what we'll hear in the 22 SCs.
So, all right. So he may have been present in the 2019, the October 19th case, and the June 2020 case. Now, I'm not aware of what the video surveillance is from the Smyrna. I'm not exactly sure about that. I checked.
Well, the Smyrna, he was arrested there. So one doesn't need video surveillance. There's a report of something going on. Anderson and your client and one other gentleman are actually arrested on the scene. Yeah. Now that's a Cobb County case, so we're not doing anything with it here. Yeah. It's intertwined. It helps connect the Lenox Road and the Collier Road. I don't mean to make a big deal out of it. I just don't see an Alford plea being appropriate in the 19 SC case. Your client is caught, as in arrested, with Mr. Anderson soon after your client and Mr. Anderson are seen clearly on video from the Collier Road. So those dots to me seem to be sufficiently connected that I'm not following the offered plea.
And I understand that, Your Honor. I'll say that the reason why we're offering why we're requesting the offered plea is because in the evidence that I did provide to my client, he did, essentially make some admissions of where he was and where he wasn't. But he also stated that in some of these cases that he was not actually on scene. And so in a proposed way to close the cases out, I proposed the offered plea saying, hey, essentially, if you feel like, you aren't guilty of everything here, this is an option, an alternative that you could take.
That is still in your best interest. You may not have been there for every single one of these, but you aren't going to wiggle out of it if the state goes to trial. Eventually, they're going to show somewhere you are.
That there's enough evidence here to find him guilty of all of these.
Okay, got it. All right, I'm good. So let's move then, Ms. Charles, to your accusations.
Yes, Your Honor. In accusation 22 SC 182624, officers responded to 786 Cleveland Avenue Southwest, which is here in Atlanta, Georgia, between March 13th and June 9th, 2020. Officers showed up on June 9th, but the evidence will show that once officers got to the scene, they made contact with the Space Shop associate, Ms. Tisha Balthazar, who noted that she came into the location that day and noticed that there was one unit had reported to her that it had been broken into. The victim in that case was Armone, Armone Burks. His unit was 3116. In looking at their surveillance cameras, they were able to note that Mr. Reed's co-defendant, one Zachary Owens, had previously rented a unit at the 786 Cleveland Avenue location, received the code. Mr. Owens used his driver's license to rent the unit. However, the payment for that unit was made by a debit card belonging to Monqueso Reed. On review of the surveillance, Ms. Balthazar and officers were able to note that later on, about 7:22 in the evening, the two males returned to the scene. Mr. Owens uses his code, enters into the initial compound, and then they proceed to enter into the area where the units were. Mr. Burks reported that the outer lock of his unit had been damaged, ripped apart, and there were some items missing. The items that he noted that were missing were amounted to less than $1,500. Officers was able to then look through Horizon and note that Mr. Reed had been linked to a similar set of crimes in the 19 SC case, and warrants were taken out for his arrest based on the license of Mr. Reed matching the face that Ms. Balthazar identified on that video. In accusation 22 SC 182707, on and between June 6, 2020 and June, let me be sure of the date here, June 22nd, 2020, at the same location, 786 Cleveland Avenue Southwest. On further review of the units that have been broken into, officers were able to identify additional victims. The first victim being Ms. Sequoia Fife, who noted that her unit 2218 had been entered and damaged. Very similar to the previous case in Mr. Burks's case, Mr. Owens entered the location along with what is later identified as Mr. Reed. On Ms. Balthazar's review of the camera, Ms. Fife later reached out to Detective Colbert to inform him of the amounts of items that she alleged to have been stolen. This is the case where it is alleged to be over $25,000, nearing $200,000, which we're going to look at restitution at a later stage. Also, on that same day, the Space Shop Storage also alleged that there was one door that goes to an administrative or an office space in the unit. That door was ripped apart or ripped open, and the entire unit door would have to be replaced in the amount of $625. And that was similarly in that same date range, in the same indictment, we have the second victim, Mr. William Shelton. His unit was entered. Mr. Shelton itemized the items that he alleged to have been taken, and there were a range of electronic items, a laptop, which totaled a little over $3,600 based on his estimation of the facts. In the same encounter at the same location, 786 Cleveland Avenue, a third victim, Bridget Riley and Sean Russell, also reported that their unit had been entered, and clothing items and a JVC television set had been taken. The total amount that they allege of items that they were missing was less than $1,500. In all of these incidents, the outer padlock had been broken and the unit was entered in the same way. Similarly, victim Mr. Stanley Porter also reported to officers that in the same date range, it was June 6th and June 22nd, same Mr. Zachary Owens, was alleged to be Mr. Reed, entered into Mr. Porter's unit, taking various electronic items, a watch, some jewelry, which he alleges was less than $1,500 in total. We also have Ms. Takesha Glass, also reported to officers that her unit was also entered and alleged that she lost multiple clothing, jewelry, and some electronic items in excess of $1,500 but less than $5,000. And finally, Ms. Sherelle Barnes also reported in the same location, 786 Cleveland Avenue. Her unit was also broken into, and she indicated loss of more than $1,500 but less than $5,000. And so, based on officers' review of the video, talking to Ms. Balthazar, the connection of Mr. Owens and Mr. Reed, officers took out warrants for the arrest of Mr. Reed as well as Mr. Owens.
What you have to add is, before we discuss the United Constitution.
Okay. Tucson, do you have any adult felony history for Mr. Reed?
No, Judge. No probation for him.
All right. And Ms. Jackson, anything on Mr. Reed beyond the cycles that would be linked to these cases?
No, Your Honor.
Mr. Reed, how old did you say you were?
34.
34? Okay. All right. Mr. Jerome, what do you want to add to everything I've been hearing?
Hold on one second, John. All right, Your Honor, essentially, let me begin with the domestic violence case. So on the domestic violence case, the reason why Mr. Reed obviously is pleading guilty to those charges is because he does understand what aggravated assault is. He does understand the possession of the firearm. He does understand, essentially what the elements of these crimes are, and understands that the state would be able to prove these crimes beyond a reasonable doubt if this were to go to trial. However, the victim in this case, Ms. Consuela Mack, did several times speak with the prosecution and speak with myself and indicate that she really didn't want to move forward with charges, and that there was a mischaracterization in the police report, in that there's a difference between him pointing the gun and shooting the gun at the vehicle. So he did not shoot the gun at the vehicle, is essentially what she's been saying, is essentially what he's been saying. But there is no dispute that the gun was shot. And so he understands that, that there is a reasonable fear of death by anybody that would have seen the gun being pointed at them at any point. And also that the sound of a gunshot could also be reasonably considered to invoke a certain amount of fear.
Sure,
in any person,
especially in little kids.
especially in young children. However, we just want to make it abundantly clear here that he did not shoot at the vehicle. Mr. Reed contends that he shot the gun straight up in the air, and it was not at the vehicle, and it had less to do with his wife and children that were leaving at that time, as opposed to other people that were trying to hold him down and hold him back and basically prevent him from trying to get to his wife. And so that's essentially where that issue came from. Mr. Reed is willing to plead guilty to those charges. However, Mr. Reed is a father. He has 3 children with Mrs. Consuelo Mack. They live together. They support each other. This has been a very difficult period on his family. Luckily, Mr. Reed has a very good extended family, and they've been trying to provide as much support for her and him as much as they can. However, Mr. Reed is 34 years old. This is his first time incarcerated. He's always been able to essentially pay his own bills, take care of himself, and take care of his family. And this has been a very humbling experience for him. He understands where he's gone wrong. He understands the errors of his ways. There was a marijuana charge that was not processed as a part of this indictment, and drug use was a factor in this incident. And so,
When you say this incident, the domestic violence.
That's correct, Your Honor.
Okay.
And so, he wasn't really of a clear mind when all of this happened in the first place. And he understands that, brandishing a firearm, let alone shooting a firearm, when anybody else is around, is absolutely wrong. And I'm saying that, but this comes from conversations I had with him, and he understands clearly. He understands that his incarceration has been a consequence of his own actions, and he's taken full responsibility for that by essentially pleading today. However, the state has requested 24 months or 2 years incarceration on this with the 10 years probation. He's essentially served 20 months. He's about 7 days away from serving 20 months. And the state has agreed to give him credit for time served. But what we would like the court to do on this is reduce the sentence or commute the sentence to credit for time served so that he may be released today. He does have employment, gainful employment waiting for him. He does have, some family members that are looking to train him so that he can basically, even though he's going to be a convicted felon, he understands the consequences of that. And there is a stigma that carries with that makes it more difficult for any individual to re-enter into society. And with that in mind, his family has set up, essentially training programs, employment, everything for him, so that as soon as he gets out, he'll get on his feet and he'll get running right away. And so it wouldn't be, an instance of Mr. Reed being released and then coming right back before you anytime soon. Like I said, he's 34 years old. He was 32 years old when he was arrested on these charges with no prior felony charges, with no real criminal history whatsoever. He just got caught up in a bad situation, and it was really just monetary. That Mr. Reed doesn't have any malice in his heart whatsoever. He's a very genuine individual. He's a very compassionate individual. He is, he's a godly individual. And so all of this was just, essentially a result of bad circumstances on his behalf. Now, in reference to the burglary charges, I already laid out that he's made some admissions, but he's also said that he doesn't believe he was involved in all of these robberies here. And so he understands that his connections with his co-defendants and his presence on the scene does make him, culpable enough to possibly be found guilty if this were to go to trial. And that's why he's taking the guilty plea on those. And we'll just ask the court to accept the plea as negotiated. It is an extremely long probationary period. However, Mr. Reed, he's gone very long in his life without having any issues. He doesn't believe that he's going to have any issues moving forward. This has been more than enough, to correct him. He's seen the errors of his ways, and he's going to be on the straight and narrow from here on out. This is not anything that would be out of his character in any way. As I said, he had gone 32 years, Your Honor, without any issues whatsoever. So we believe that in this case, an immediate release would be appropriate. And we're just asking the court just to modify the negotiated plea slightly and allow Mr. Reed to get on the domestic violence case credit from his sentence with 2 years reduced to credit for time served.
So that's not what was negotiated. You're asking for something other than what was negotiated.
That is correct, Your Honor. And it's a 4-month difference essentially. And I understand that that may not seem like a lot of time, but for someone who's incarcerated and, you know, who has a family on the outside, and regardless of what the facts in this case are, he loves his family very much. He loves his children very much. His children love him very much. He calls them every day. They call him every day. And, you know, these are paid calls. His family is not rich. And essentially they make that sacrifice because of the love that they all have for each other. And so another 4 months incarcerated is just, you know, it's already had a significant emotional toll on him. And, you know, and also, Your Honor, I want to go back to the issue that we had previously spoke about during the bond hearing, is that he does have these seizures periodically. And though he hasn't had one, there's still that fear that he could at any moment have a seizure. And, you know, it only takes one day of being in the wrong place and having that seizure, and then he could drop dead. And he doesn't, and, you know, we just want to avoid anything of that sort. And so he just feel that being home, he would get the proper care and he would be on the proper doses of medication that he's been asking for from the sheriff department for over a year now. And, you know, essentially we feel like it would be in the best interest of all the parties. And we think that it would be a proper administration of justice if he were to be released on time served today, Your Honor.
Okay, I follow all that. I may have missed something in the discussion. Are you seeking first offender on behalf of Mr. Reed?
Yes, we are, Your Honor.
Okay, I didn't miss it then. Because you also said in your presentation just now that he'll be a convicted felon, which he wouldn't be if he's a first offender. Does the state have a perspective on first offender, starting with Mr. Thomas?
No, Your Honor, we're not going to object to first offender.
Ms. Charles?
No objections.
Okay. All right. Mr. Reed, is there anything you want to add to what Mr. Jerome just said about your situation?
No, he's accurate. No, I don't. Yeah, he's accurate what he said. I don't have anything to say.
Okay. What kind of work were you doing that did not involve breaking into storage units before you got arrested?
Well, I worked at Wakefield and I was working at a car wash.
Car wash? And then Wakefield is that grocery store?
Yes.
What did you do at the grocery store?
Unloading the truck.
Ms. Mack, are you and Ms. Mack married, or you have a long-term relationship and you have kids?
Yeah, we've been together like 12 years.
Okay. How many kids do you have with Ms. Mack? 3?
Yes.
How many kids total do you have?
4.
4. Offered plea. You are entering an offered plea to the 3 cases that involve these burglaries. You understand that an offered plea is when you are effectively telling me, Judge, I didn't necessarily do everything the state says I did in those cases, but after talking with my lawyer and thinking about this, I don't want to go to trial. It's in my best interest to just say, all right, I'll plead to those cases. So I may have done some of it, maybe a lot, but not all of it. But I'm just going to say I plead, but it's under offered. Is that what you want to do?
Yes.
Okay. Those will still be convictions, even though you're saying I don't agree with everything the state says. You are saying I'd rather take a plea than go to trial. Is that correct?
Yes.
Okay.
May I speak, Your Honor?
So, Ms. Yvette, you need to leave your phone on mute, okay?
What was that?
Hey, thank you. I just wanted to see if I could say something to you.
All right. We're just going to remove Ms. Yvette. All right. All right. Let's get back to where we were. Was Yvette someone with you?
That's my mother.
Okay. So, Mr. Reed, I find there is a factual basis for your pleas in the 4 cases we're working through, that you and Ms. Mack were having some kind of disagreement, and there was enough going on that you thought, I'm gonna pull out a gun. Never a good idea. And even worse, you pulled the trigger. It sounds like there's a lot of confusion as to which way the gun was pointing, but the gun pointing any way other than into a holster is a bad plan. And that's a real serious situation. Even if you weren't intentionally aiming it one way or the other, there's a crowd around there, shoot a bullet up in the air, it doesn't go into the sun. It comes back down. And there are plenty of people who are hurt because at New Year's or 4th of July, like, hey, I'm gonna shoot a gun up in the air. Those bullets come tumbling down and folks get injured. Even worse would be if you weren't pointing it quite up in the air. And whether you shoot your own kid or someone else's kid, it's not a good plan to be pulling that trigger. And of all the things you're charged with here, and you're saying, yeah, I got mixed up in, that's the one that worries me the most, is that you got kind of hot and bothered about something. You thought the way to handle it was pull out a gun and pull the trigger. I didn't hear any evidence. It was, well, I did it because these 3 big guys with assault rifles were coming at me. That's self-defense. This doesn't sound like it was that situation. That needs to not happen again. As to the burglaries, it sounds like you and Mr. Owens and Mr. Anderson and some others had a good little racket going. You know what? We're gonna rent a unit and that'll get us in there in the dark of night, and we'll pop the locks in other units and we get stuff and we sell it and we make some money. It's not okay. You're taking other people's stuff. It seems like it worked for a while and it happened a lot. And maybe that helped supplement the car wash and the Wakefield income. I also find that your pleas are knowing and voluntary. Voluntary means that no one's forced you into these pleas to the 4 cases. You're doing it because you and Mr. Jerome have had good, long, maybe difficult conversations about what's next. And you've decided, Mr. Reed, that it's in your best interest, not Ms. Max or your kids or your mom's, but your best interest to enter a plea in each of the 4 cases. Is that correct?
Yes.
Okay. And I find that your plea is knowing, which means I find that you've understood all the things we've been talking about. And we stopped every once in a while because you had a question from Mr. Jerome, and that's great. Do you have any questions now about anything anyone has talked about?
Yes, sir.
No? Okay. Then I'm accepting your pleas in all 4 cases. I'm sentencing you pursuant to the Probation Options Management Act. And what that means is, hold on one second. What that means is that you, while you're on probation, if you have a technical violation of your probation, maybe you miss a meeting with a probation officer, something small, you and probation will work that out. You don't have to come see me. But if it's a more serious violation, you get arrested again, or there's any violent contact with Ms. Mack, then that comes back to me, and I'm gonna have a lot of probation to work with, because on one of the cases, you have 20 years of probation. And if you violate a special condition of probation, I can revoke all of your probation. So hopefully nothing like that happens. All right, I am not going to give you first offender status, so I don't need to tell you the benefits and risks of first offender. There's too much going on here for this to qualify as first offender. In the case ending in 151, so let me state the full number, 21 SC 178151, the case that's different from all the others. It's the one with the gun. I'm going to sentence you. Let me get the indictment in front of me so I'm getting all the counts. On counts 1 and 2, I'm sentencing you to 10 years to serve 2.5 years with the balance on probation. And count 6, actually, I need to change that. Counts 1 and 2 are 5 years to serve 2.5 years. They'll run concurrently with each other. Count 6 is going to be 5 years to serve 2.5 years. That'll run concurrently with count 1. And then count 8 has to be 5 years and it has to be consecutive. And I'll probate that. So the total sentence in the case ending in 151 is 10 years to serve 2.5 years with a balance on probation. So 7.5 years of probation. You'll get credit for the time you've served. You'll need to complete a family violence intervention program. That's a special condition. And no violent contact with Ms. Mack, which would be a crime anyway, but I'm adding it as a special condition because that would be a basis to revoke the remainder of the probation in that case. In the case of 19 SC 173786, I'm giving you 2.5 years to serve on each of the 4 counts. They'll run concurrently with each other and you'll get credit for time served. So when you're released, the case ending in 786 is dismissed. In the case of 182624, your sentence on count 1 is 2.5 years to serve. Your sentence on counts 2 and 3 are both 12 months to serve. Those will run concurrently with count 1. You'll get credit for time served. So when you're released, the case ending in 624 is closed out. And so we're clear, your sentence across all 4 of your indictments is running concurrently. They're all running together. Nothing is stacked like that. In fact, the only thing that's stacked, that 1 gun count, it has to run consecutive. That gets us to the long one. And I guess here, maybe some things have to run consecutive to get this 25 years. So the case 22 SC 182707, your sentence on count, the burglaries in the 2nd degree are what? Or they differ because of the dollar amounts?
No, they don't differ dollar amounts. It's theft by tickets differ.
That's what varies. The burglaries in the 2nd degree are, all right, but what's the range?
I was 1 to 5, Your Honor.
1 to 5. Okay. Then these do need to run consecutive to each other, but this sentence will run concurrently with all the others. And I'll summarize all this in the end, but I have to get this on the record so it's clear what your sentence is. So count 1 is 5 years to serve 2.5 years with a balance probated. You'll get credit for the time you served. Count 2 and 3 are both 12 months to serve. They'll run concurrently with count 1. Count 4 is 5 years probated, consecutive to count 1. 5 and 6 are both a year to serve or 12 months, depending on whether it's a misdemeanor, concurrent with count 1. Count 7 is 5 years probated, consecutive to 4. So now we're at 15. Counts 8 and 9 are both a year or 12 months to serve. And they'll run concurrently with count 1. Count 10 is 5 years probated, consecutive to count 7. That gets us to 20. 11 and 12 are a year or 12 months to serve, concurrent with count 1. 13, 14. The remaining counts, so counts 13 onward, are all 1 year to serve or 12 months, concurrent with count 1. So your sentence in the case ending in 707 is 20 years to serve 2.5 years. So it's a little less probation than you were going to have. 20 to serve 2.5, balance probated. You will need to pay $20,000 in restitution. You don't need to worry to which of the victims that goes. Over the course of those many years of probation, you'll be paying it down as you're able, and you will never have your probation revoked because you cannot afford restitution. That's not how it works. Now, if you win the lottery, You win $50,000 and you don't pay any restitution, then you may get sent to jail so that you disgorge some of that. But if you're working hard at whatever your job is and you can only pay a little bit of restitution over time, that's what you can pay. You will also need to stay away from this storage location at 786 Cleveland Avenue Southwest. Don't ever step foot on that again. And you'll be subject to Fourth Amendment waiver, which just means a probation officer could search your house or your car or something if they show up and say, hey, we just want to make sure everything's going okay. Mr. Thomas, did I miss any conditions of probation that you thought ought to be in the mix?
So no, Your Honor, I did remember you said no weapons, family violence intervention, and no violent contact. So that covers.
I did not say no weapons because that's the law. He can't have a firearm because he's a convicted felon. I did say no violent contact. I did say family violence intervention program.
Yes, Your Honor. So that sounds good.
Okay, Ms. Charles, anything you want to add to the sentence?
Yes, Your Honor, just stay away from the co-defendants. For example, Mr. Owens, this case is currently in judicial hold, so he's in the wind somewhere.
Okay, sure. So Mr. Reed, one other condition of your burglary cases is stay away from your co-defendants. So Garrett Anderson, Zachary Owens, you need to, insofar as they're the reason how you got mixed up in this is a good condition to have, but you got to leave those guys alone and they're going to leave you alone. We see if there is anything else. I've covered all of it except for you've got 4 indictments that you're pleading to right now. They're digital, they're on a screen, and I need to put the lawyer's signatures on it and your signature. Do you authorize me, Mr. Reed, to electronically sign your indictments?
Oh, do you understand the sentence that the judge was handing down?
We'll get there in a minute. I'm gonna let you two have that conversation.
Okay.
Let me cover the signature part, then I'm going to cap it all up again. And if you two need to talk, you can do that. So assuming we're going forward, do you authorize me, Mr. Reed, to sign the indictments for you?
Yes.
And Mr. Jerome, can I sign for you?
Yes, Your Honor.
Okay. And Mr. Thomas?
Yes, Your Honor.
And Ms. Charles?
Your Honor.
All right. Mr. Reed, the overall sentence that you're getting here, the part that you're going to focus on initially is your lawyer said, please give him time served. Your lawyer actually negotiated 2 years to serve, which means you do a few more months. I, as the judge, in looking over all this stuff and all the different things you were involved with, and the fact that there were some other cases that got dismissed, have decided that you ought to do a little more than 2 years, not 5, not 10, but 2.5. That's the sentence I'm imposing. And it's followed by some probation. And that probation is long. It's not as long as actually was negotiated, mostly for you to be able to pay the restitution. If you're able to pay that off, then your probation can end early. It wasn't a long term of probation because I want people looking over your shoulder. It's realistic that unless you suddenly make it big time because the Falcons sign you or something, it's going to be hard to earn that restitution. And so you'll be paying it in small amounts. But that was my thinking, and it's why I did what I did. Mr. Jerome, do you need a minute to speak with Mr. Reed, or are we able to go forward?
Yes, let me speak to him for a second.
Okay. You want to do it right there, or do you want to do it in lockup?
Yeah, let's go back and lock up.
Okay. Thank you. Yes, the 3 burglaries are offered, please.
What do you got left for the rest of the day? What do you got left for the rest of the day? I got to
Ms. Jackson, you are free to go if you want to roll off. We need to keep Ms. Tucson on in case we need to get some probation reporting instructions for Mr. Reed. Thank you. Thanks for your help. All right, Mr. Jerome, are we moving forward in resolving Mr. Reed's 6 cases?
Yes, we are, Your Honor.
All right, Mr. Reed, last thing we need to do, Ms. Tucson, who is with probation, she will not be your probation officer, but she's with probation. She needs to give you some reporting instructions because you're going to be getting out soon. And when you get out, one of the first things you do besides hug your family and be glad that you're out is that you'll report to probation. Okay? Ms. Tucson, what do you need from Mr. Reed?
Good afternoon. I'll need address and phone number, Mr. Reed, and what do you know what county you'll be residing in?
Fulton County.
It's Fulton. Okay. What is your address?
125 Logan Street.
Logan,
Yes.
Logan Street. Okay.
Apartment 223.
223. Okay.
221.
221.
You should feel free to correct him if he gets it wrong because they're going to mail stuff to him. We don't want him to miss it.
125 Logan Street, apartment 221, Atlanta. What's the zip?
30312.
And do you have a phone number we could put on file?
404 482 4648.
Nope, hold on. That's a bad number.
Okay.
Say it again.
754-0343.
Okay, 404 754 0343.
404-754-0343.
Yes.
Okay, and Mr. Reed, do you know where probation is on 276 Memorial Drive?
I can find out.
He's never been there before, so maybe Mr. Jerome could write this down for him.
And just make sure when you are released, you report within 48 hours to probation. They'll do your intake there and give you all your information.
Okay.
And failure to report will result in a probation warrant for these cases.
So within 2 days of getting out, you got to make sure you show up at the address that Mr. Jerome's going to give you, and they're going to know who you are. You just say, hey, I'm Mr. Reed. They'll be able to look up your cases. They'll have the sentences, and they'll get you situated. Okay? Any questions?
The release won't be within the next week, right?
No.
Okay.
Any questions about anything, Mr. Reed? All right. I wish you the best. You got family that cares about you. You have had more people come to court for you than almost any other defendant I've been working with. And you've had a few people intermittently trying to connect on Zoom. They just were a little boisterous, so we had to move into the waiting room. So you've got a support group. Don't let them down when you get out, okay? All right. Thank you, Mr. Jerome. Thank you, ADAs.